Victim is item number 5, my lord.
5.
Yes, Lord, sir.
5 and 6.
5 and 6.
And
my lord.
that is my problem.
Can you be on 13th, my lord?
Huh?
Last week of this month, my lord.
Actually, I will know. Last week of this month is basically 3 days only. Because on on Thursday holiday and then Friday we have to, at least I have to be in Srinagar. So that be hardly any time. After vacation.
28, my lord.
After
28.
vacation. On the prayer for adjournment made on behalf of the. For whom are you praying? Who
PK
made the application
PK
for
PK Das.
adjournment? Huh?
PK Das, my lord.
For adjournment made on behalf of Mr.
PK Das, my lord.
P.K. Das, Learned Counsel for the Appellant,
My lord.
which is not objected to by the other party, other councils. This matter after the vacation.
May please, your lordship. I like to mention item number 9, my lord. My lord, can it be accommodated on 20th, my lord, of this month, my lord? Because bail application is also there, my lord. That will be on 20th of this month, my lord.
Paper book is ready, your lordship.
Huh?
Paper book is ready.
Paper book is ready. That entire matter can be heard at that time also on 20th, my lord. Because I have filed a petition on the 391 also.
What is 39? What?
391 I have filed because I have annexed with the
Lordship,
FIR.
probably bail was heard once.
No, it will be decided.
But
No,
bail-
if the paper book is ready,
Yes.
we decide the entire matter.
Yeah.
Why should we only pay?
On Tuesday on 20th, my lord. 20th, my lord.
For item 9, you have not made any written prayer. You have only prayed, there is only another one for 8 only is there.
My lord.
You are supposed to have made an application for adjournment as per the notification issued by this court.
Yes, my lord.
Huh?
I have given the bail application was heard, which was decided that it will be heard together at the time of hearing, but final hearing, my lord. Because I have filed another petition, my lord.
Mr. Counsel, I'm not on that issue. I'm on the issue of if you are going
My
to
lord,
ask,
let it be heard on 20th, my lord, entire matter.
let the registry decide if you want.
My lord,
We
because
cannot adjourn it just like that. If you want, we'll hear it today.
my lord, I have filed one IA, my lord, for 391.
So,
Those documents will be necessary, my lord, because it is arising out of the same GD entry. In the same GD entry, 2 FIR was lost. One was acquittal, other was convicted. So that judgment is also required, my lord. That is why I prayed, my lord, let it be on the 20th, my lord, of this month, my lord,
for what?
to decide, my lord, that.
Where's the question? When you want the documents, when you want certain documents, where's the question of deciding the entire matter?
Because it is based on those findings also, my lord, because of the session just put. Because that is the law points, my lord, where it has to be decided, my lord. That is why, my lord, I'm praying that it may be on 20th, my lord. That is my humble
I think some
request, my lord.
matters are not
Lordship,
fixed.
those matters, those documents never been placed on record by the
No, I have
court.
that's what-
requested. The
Now
FIR
at this appellate stage, whether it can be.
Yes, that is why 391, my lord. That is why 391.
Oh, you are filing 391
One, yes,
application.
application I have filed. Sir. So, my lord, I beg, my lord, let it be on 20th, my lord. He is behind the bar, my lord.
22 matter. I don't know. 22.
That is why my paper book was
NDPS.
ready, my lord.
NDPS.
Yes, well, that is why the paper book was ready, my lord.
Okay, 22. List the matter on 20. We'll see.
Oh, my lord, highly obliged, your lord.
22nd, your lordship.
Not 20th, please, 30.
Please.
22nd, you want
No,
20.
20th. Highly obliged, your lordship.
On the prayer made by the Appellants Council.
May it please your lordship. Lordship, item 8 supposed to be adjourned on the prayer of the respondent. They have taken consent from me yesterday, lordship. Item 8, lordship.
Yes. So who is for the respondents?
Respondent, the engaged counsel is not present, Lordship.
It's a matter fee.
Huh?
Matrimonial appeal.
I know, but then there is an application for
Ah,
adjournment. Hey, this is it.
Perhaps they thought that that application will be enough and they did not mention. Mr. P. Bhomik and Mr.
Okay, right. On the prayer for adjournment made by Mr. P. Bhomik, learned counsel for the
Respondent.
respondent. And which has not been objected to by the learned counsel for the appellant. This is the matter after the vacation.
Lordship. Public.
Malad, with all respect, my lord. Convicted under section 302, sentence is life, my lord. Here at the outset, my lord.
Huh?
At the outset, my lord, with all respect, my lord. The judgment, my lord, there was a cross case, and the cross case judgment and the present appeal, my lord, both were decided, my lord, by the same judgment disposed of, my lord. That is, my lord, at the outset, I must place, my lord, that is possibly not in accordance with law, my lord. There are several authorities, my lord, because by the same judgment, the present appeal, my lord, with all respect, my lord, that judgment and the cross case judgment, may I just place it, my lord? That is, with all respect, my lord, that is at page 164, my lord. 164, my lord.
Yes.
My lord, with all respect, my lord, 164, if I read it, my lord, in the Court of Session Judge Borpeta, Assam, Sessions case number 131 of 2014. Here we have been convicted, my lord, with all respect, my lord, and the cross case we lost, my lord, but the same judgment it was disposed of, my lord. If we come little bit down below, my lord, same page, my lord,
Yes,
Sessions case number, page 164, my lord.
yes,
Sessions case number 347 of 2015, my lord.
yes.
So this is the cross case, my lord. We lost, there they were acquitted. That's besides the point, my lord. But my lord, there are same judgment, whether it can be done or not, my lord. And thereafter the pages I am placing, my lord. Page 167, my lord.
Yes,
Page 167, my lord. My lord, points for determination. After hearing both the party, I'm reading from the top, my lord, 6. After hearing both the party charges are framed, then thereafter, my lord, 8. Points for determinations. In Sessions case number 131 of 2014, these are the points, my lord, and thereafter, in the same judgment, my lord, next page, 168. Points for determination in Sessions case number 347 of 2015. Because the evidence in the cross case cannot be taken into account while determining the guilt or otherwise in the main case, my lord, with all respect, my lord. And thereafter, my lord, this is, my lord, I'm
so
placing-
your case is that the evidence that was adduced in 347 has been used in 131.
yes, my lord, that has been used. Why I'm placing, my lord? If
But
I-
they might have, there must be separate evidence taken in 131 also.
Yes, my lord, but it cannot, the law is very clear. Why I'm placing, my lord, if I argue, my lord, my case is a very, so far as I'm concerned, my lord, I feel it's a good case. But if I place it, my lord, at the outset, I must place the inherent defect in the judgment, which cannot be cured possibly.
We'll see, and we'll see with the evidence that is recorded.
If I, can I just read it, my lord, and then thereafter place one authority, my lord. This is besides the law, my lord. And thereafter, my lord, page 200, my lord. The judgment of the cross case and both the cases are intermingled, my lord. That cannot be done, my lord. This is because the law is this, my lord. That's why I'm placing it at the outset, my lord.
Page 200.
200, my lord. 200, I'm beginning from the first word, my lord. Lordship is from my lord. 200, my lord.
Yes,
With all respect, my lord, unbelievable statements of the accused persons of Sessions case number 13114 that they do not know how so and so died. They only heard about his death from the evidence on record of both the cases. It is crystal clear that the said occurrence Sirajuddin must have sustained injury. Initially, he was taken to hospital at Patsala, wherefrom he was referred to GMCH, where he succumbed to his injuries. Thereafter, my lord, leaving aside 4-5 lines, my lord, filing of FIR by Sirajul Haq Bhuiya, on the basis of which session case 347/15 is started, proves that at the time of occurrence, Sirajul Haq Bhuiya, this goes on and on, my lord. The evidence of the cross case is taken into account in the main case, and the evidence in the main case has been taken into account in the cross case. If I read the judgment in totality, because both the cases were disposed of by a common judgment, this is the judgment, my lord. With all respect, my lord. And the law, my lord, with all respect, my lord. This is the beginning, my lord. We may just place it, my lord, with all respect, my lord. 1990 supplementary, page 145. Nathi Lal, my lord. This is the. And there are several authorities of our High Court also, my lord. Nathi Lal is the, my lord, game changer, my lord, with all respect, my lord. There, my lord, para 2, leaving aside 5 lines from the top, my lord. Leaving aside 5 lines from the top, my lord.
yes.
Para 2, my lord. Nathi Lal, para 2, my lord. I'm reading the entire paragraph, my lord, para 2, my lord. We think that a fair procedure to adopt in a matter like the present, where there are cross cases, is to direct that the same learned judge must try both the cross cases, one after the other. After recording of evidence in one case is completed, he must hear the arguments, but he must reserve the judgment. Thereafter, he must proceed to hear the cross case, and after recording all the evidence, he must hear the arguments, but reserve the judgment in that case. This is the, my lord, we are putting emphasis, my lord. This is the ratio, my lord. The same learned judge must thereafter dispose of the matter by 2 separate judgments. By 2 separate judgments. In deciding each of the cases, he can rely only on the evidence recorded in the particular case. This was given a goodbye, my lord. The evidence recorded in the cross case cannot be looked into, but here it has been looked into. Nor can the judge be influenced by whatever is argued in the cross case. But here the reverse has happened. Each case must be decided on the basis of evidence which has been placed on record in that particular case without being influenced in any manner by the evidence or arguments urged in the cross case. But both the judgment must be pronounced by the same learned judge, one after the other. Here, my lord, 2 separate judgments, my lord. And there are other authorities, my lord. This is the beginning, my lord. Harbingham, my lord. Then thereafter other authorities about court and FX court as well, my lord.
Same line.
Absolutely.
Sure.
Yes,
What's the latest?
exactly.
You must have looked up the notar up or something like that.
Yes. This is, my lord, with all respect, my lord. 2003, my lord. State of MP versus Mystery Lal, my lord. Here, just, my lord,
Citation.
the citation is, my lord, with 2003 9 SCC 426, my lord. There, my lord, the ratios, my lord, cross cases to be tried together. And thereafter, my lord, here, my lord, this Nathulal has been quoted extensively, my lord, that particular paragraph. I'm reading, my lord, with all respect, my lord, this is the head note, my lord. Cross cases to be tried together. Para 7 at page 43 that occurs, my lord. And thereafter,
Page
next
43,
430, my lord.
433.
430, my lord.
Yes.
430, my lord. Cross cases to be tried together. Down
Yes.
below, my lord. Head note. Thereafter, my lord, I turned the page to 431, my lord. There it says, my lord, the beginning of the line, my lord, leaving aside some words, my lord. This court in Nathilal that I read out, my lord. This is the authority in Nathilal versus State of UP pointed out the procedure to be followed by the trial court in the event of cross cases. So, my lord, that I read it out, that particular paragraph, my lord. It has to be by two separate judgments. The evidence of each case is to be taken into account. In that particular case only, my lord, with all respect, my lord, it cannot be intermingled. Here it is intermingling, my lord, with all respect, my lord. And thereafter, my lord, in the instant case, it is undisputed that the investigator, but this is besides the point, my lord. But this has been done, my lord, without following these authorities. This is the law of the land, my lord. With all respect, my lord. And thereafter, one authority of our High Court, my lord.
Is there any Supreme Court authority after 2003?
My lord, that we'll have to do our homework, my lord. So at least we have.
There is a recent judgment by Honorable Chief Justice Chandrachud.
Hmm.
And not exactly on the point, but there what had happened is two separate trials were conducted. After that, two appeals were filed, but High Court disposed it
Amalgamated.
together.
Hmm.
That was considered to be wrong and it was remanded back.
Okay, so out here, if the High Court
Hmm.
has amalgamated it and that was considered to be wrong, then,
This is 2023.
no, then
Huh.
it would have been more wrong if the trial court had done the
I have not done
same
that.
thing. I know.
So that's always correct. my lord.
Otherwise, it's a
And,
settled position.
why don't we look up, notar up or something, just in case there has been a change in the law?
Lordship,
Because we'll be laying down a law in a way.
Yeah.
So, I mean, the
Citation she is
SEC
saying,
notar up,
she is, my lord, saying is 2021 SCC online. SC
2021 SCC online.
online SC 1017, my lord.
No, it's reported in SCC also.
What is the citation?
No, SCC, it's not reported. I've taken up from
Which
Manupatra.
para is it?
This is, party's name is A.T. Maideen.
80, my dear. Yes, yes.
I have given the mail. Lordship can see that case. The Lordship, there will be a mail to court number 4.
Para 25, my lord.
Huh. A.T. Maideen versus State Assistant Commissioner. It was decided in 21 years, October.
Can we just see the judgment?
Lordship. A.T. Maideen.
So basically, your submissions
Yeah,
are in
last night,
tandem with
last
each
night.
other.
Lordship.
Your submissions
Well,
are in tandem with each other. You're not denying
Hmm.
or objecting to his submission.
No, no, this is a settled position of law.
Then it has to be remanded back.
In that
Well,
case, in 21 case, it was remanded.
My lord, lordship is very correct, my lord. I face the law, my lord. I leave it to your lordship.
Mhm.
My lord, have I made my position clear, my lord? This is the law, my lord. If I begin from the beginning, my lord, and at the
Correct,
end, if I
correct.
place it, it will be wastage of your lordship's time, my lord.
And your time.
I'm not my time. I'm not
I've
saying
sent
that.
it again, I've sent it again. রাখি? ও শামীমা জাহান বলে বকিটা গাছ মরেছে।
But if 21 government is. Okay. Mr. Data.
There are analogous matters also.
Oh, the other locus, man? Yes. Acha. Mr. Anshuman, what do you have to say?
Yes, ma'am, that's a correct proposition of the law. There can be a trial together, but the both has to be a separate judgment. But it has to be by the same judge, by the same court. If there is cross case, there's no doubt about it. But there has to be a separate judgment, and each judgment has to follow its own merit. It cannot be used in.
They
each
cannot
other.
juxtapose the evidence
Yes,
in both the
that's not
cases.
So when the juxtaposition here, the same thing has happened, and the learned trial court even relied some of the evidence of the other case where he has been acquitted, where we have filed the case, my lord, some of the material, and one of the accused has been convicted on the basis of the other judgment because he filed that FIR. So he has taken the cognizance of the fact that as you have filed the FIR, the cross case, that means you are present in that particular place.
Okay, okay.
Though in this, here, there's no material of his presence, but because he has filed the FIR in the other case, the presumption is taken against my client that as you have filed the FIR in the other case, so there's a presumption that you are also present in the place of occurrence.
So, so out here, the basic thing will be the stage from which the trial court will have to decide the issue.
Yes,
It's from the stage of hearing.
yes.
I
He's
mean,
setting
that's
aside the judgment.
Argument, my
He's setting aside the judgment, and he can heard it afresh.
They'll have to have a fresh,
Yes.
a fresh
Sep-
hearing is required or
Separate
Fresh,
trials.
fresh hearing, madam.
fresh hearing, I think.
Fresh
Fresh hearing is required.
No, in fact, there has to be separate trials.
No.
One after the other.
No, separate. Where does it say that?
One
Separate
after the other,
It
separate
is said in
trials.
Nathulal, my.
In a separate trial.
Separate trials.
Yes,
But it is not from the stage of litigation.
Yeah.
We are
It may be-
in tandem, my lord. It is from the stage of argument.
it is in this state of argument, it has to be separated, madam. Now the both the
Correct.
argument has to be heard separately.
Correct. The hearing
Yes,
will be done one case after the other.
yes, exactly that is
And
the judgment.
so
One case
there
after.
is no requirement of having a fresh trial.
Yes, it's no requirement.
I think.
No. Yes,
Only from the stage of
yes,
hearing
absolutely. correct.
and depending upon one case, one
Yes.
case, and then the next case.
Yes.
That's all.
That's all.
That's all has to be done.
But I think in this Chief Justice Chandrachud's judgment is separate trials because one after the other. So one trial is separate, other trial is separate. It's not
That is-
from the date of argument.
But here they have amalgamated in the judgment, both the cases.
No,
together.
you see, the trials have been separate.
Yes.
The evidences can be separated.
Uh-huh.
This, okay, it might have been done on the same day, but the evidence will pertain
To in a
to
particular
one
case.
particular
Yes.
case only.
Yes,
It will not say, the evidence will not say that this evidence is for both. It will
Yes.
say, it will relate to a particular, and we can see the evidence in front of us also. Whether it is being done in respect of a particular case or two cases. I mean, depending upon the witnesses, are they common witnesses, common prosecution witnesses?
Some are common.
some of the common, but it doesn't, if the common witnesses, it has to be in the same, different case. Case number will be different, my lord. There may be a common witness, it has to be common, some of the witnesses may be present,
No, now supposing,
yes.
now the thing is that if there is a common witness in
Yes.
both the trials, then he will have to be examined twice.
Yes.
Then we will have to see whether there has been two evidences recorded of the same prosecution witness.
Yes, madam, that has happened.
Huh?
That has happened. Possibly.
Are you sure? So we'll let the trial court decide that issue. है ना? It is required. Yes. Whether separate evidence has been
Madam,
required.
but can we have a look at case 200, madam?
200.
200.
200. Yes.
May I just read it, madam? Last three lines of 200, madam.
Yes.
With all respect, madam.
Yes.
Furthermore, PW2 and PW3 of Sessions case number 347/15 do not support the case of Sirajul Haq Bhuiya made in Sessions case number 347/15.
Yeah.
Apparent, my lord.
Yes. No. You see,
Thereafter, my lord, with all respect, my lord. Rather, they have supported the case of Sessions case number 131/14.
no. You see, that is not the question. The issue is
Fine.
whether the common witnesses, prosecution witnesses, have adduced evidence twice, once in respect of the main case and once in respect of the cross case. If there is only one evidence, then they'll have, and then that will have to be related to one particular case. And then another evidence will have to be recorded. So let us see from the records are here.
Yes.
Just show them, just see.
My lord, Lordship may kindly have a look, my lord. Always, maybe I'm wrong, my lord, that may be the answer.
No, you can see it from the evidence,
194, my lord.
194.
Last paragraph.
Yes.
194. Independent witness PW2, Duran Ali and PW3, Rustom Ali do not support the prosecution case. Rather, they have supported the case of Sessions case number 131/14. According to PW2, Duran Ali, 4 or 5 persons armed with lathi assaulted Siraj Master, the deceased, my lord. He informed to the family members, and when his family members arrived, Sirajul Haq Bhuiya, Tajuddin Bhuiya, so and so, my lord, these names, my lord, and thereafter, my lord, so and their brothers assaulted Siraj Master with dagger and lathi, and also assaulted brother and daughter-in-law of children of Siraj Master.
No. You see, we can see the paper book itself. Let us see the paper book.
My lord.
Let us see the index. In the index,
Because, my lord, PW3,
the
Duran Ali.
position of PW 1 to 26 is there. And then let us
This
see.
Duran Ali is in both the cases, my lord.
Now there is only one evidence.
My lord.
Then that means separate evidence will have to be taken. As per your
Some
judgment,
people are 80 years of age.
what to do with the law? You have brought out the law. You want us to follow the law laid down by the apex court. Then what to do? We have got to direct similarly. That's
And that is clear from, my lord, with all respect, my lord, that common witnesses, my lord. 205, Duran Ali is PW2, my lord. In the main case,
just a minute, huh? You see, in deciding each of the cases, he can rely only on the evidence recorded in that particular case. Now,
here it has been done other way.
where there are only one set of evidence.
Yes.
So that means there have to be two sets of evidence when they are the same witness for both the cases.
Absolutely.
That is why I
Then
said
Lordship
separate trials.
Can do one thing, the witnesses who has been examined, not examined in the other case.
Huh.
They can be recalled, only that part.
Huh.
Not going for the entire.
That will leave it up to the trial court. We tell him
Yes.
that,
the witnesses,
Specific words.
specific words, yes.
when
Only
there
the witnesses-
there are similar same prosecution witness, common prosecution witness in both the cases, then now the evidence that was recorded, the problem is he would have recorded only with a particular set of facts, or he would have recorded it with both the cases, in respect of both the cases. That is the problem.
Now he has to again record in both the cases, in
Yes,
the
sir.
other case also.
Yes. He'll have to again make to record it twice,
Separate trials, meaning.
separate.
Only those witnesses who has been.
Well, only and in
Common
respect
witness,
of yes, in respect of those witnesses who are
Who are
relevant.
common in both
who-
cases, my lord.
Yes, only for those. Correct.
Lordship, before
And the-
deciding can see that to 23 judgment.
Yes.
Paragraph number 25, if your lordship sees.
Para 25.
Paragraph 25 on cross cases.
Yes.
Lordship got it? So far as the law for trial of the cross cases
Just
is
a minute,
concerned,
madam. 1 minute.
paragraph 25 starts with, so far as the law,
Yes.
yes. So far, Lordship Kalita got it. Yes. So far as the law for the trial of the cross cases is concerned, it is fairly well settled that each case has to be decided on its own merit, and the evidence recorded in one case cannot be used in its cross case. Whatever evidence is available on the record of the case only has to be considered. The only caution is that both the trials should be conducted simultaneously, or in case of appeal, they should be heard simultaneously. However, we are not concerned with cross cases, but are concerned with an eventuality of two separate trials for the commission of the same offense, two complaints for the same offense for two set of accused, on account of one of them absconding. So absconding part lordship can skip, but there has to be two separate trials. This was done in this particular case, but High Court clubbed it together.
No,
So remanded
in this case.
in the facts of this
Yes.
case.
So but anyway,
Simultaneously, one
yes,
after the
yes.
other.
but what the apex court is basically saying
Hmm.
is that there should be two separate trials.
My lord, my lord, my lord.
So now what the counsels for the appellants are saying
Hmm.
is that they are common witnesses
Hmm.
and there are witnesses who are relatable to one
Hmm.
case only.
Yes.
So for those witnesses
Hmm.
who are not common witnesses, those evidences can remain.
Yes.
And for those who are common witnesses,
Reference.
fresh evidence should be recorded pertaining to each of the case. So there will be two evidences recorded,
In that way, there will be two separate
two
evidences.
separated.
And thereafter the fresh judgment.
Naturally,
Fresh
that
argument.
means thereafter there'll have to be fresh 313 also.
Fresh
Fresh
theory.
Fresh 313,
Fresh argument, fresh judgment.
Fresh 313, fresh judgment, fresh argument.
everything.
Right.
Remanding part, lordship will see on the last paragraph, paragraph 42 of that judgment.
42, yes.
Remanded to the High Court to hear it separately. 43 may be seen, 43.
Yes.
There is one more angle to be considered, that is whether to remand one case to the High Court for fresh decision. That is the case in which evidence was not considered and we may proceed to decide the other case here. We find if we adopt such a procedure, then no fruitful purpose would be served. And in fact, it would be an exercise resulting in complications and contradictions. If we proceed to hear one appeal wherein the evidences have been considered by the High Court, and we agree with the same, then it would influence the High Court in deciding the other matter on remand. Further, even if we could hold back this appeal and await decision of the High Court in the matter which we remanded, then also High Court would not be able to take an independent decision and would be influenced by the judgment as we would be entertaining a one appeal. Moreover, if we allow one of the appeals which we are holding back, then nothing may remain for the High Court to decide. There is another reason why we are inclined to send back both the matters to High Court, which is fundamental. We find that the learned single judge of the High Court has apparently not adopted the correct procedure prescribed under law, and therefore the judgment of the High Court needs to be set aside. Once a common judgment is set aside for one appeal, it cannot be upheld for the another appeal. There cannot be severance of judgment, particularly when it arises in a criminal case, where the rights of the accused are as important as the rights of the victim. Therefore, it would be in the fitness of things and in the interest of justice parties that matters are remanded to the High Court for a fresh decision in accordance with law and in the light of the discussion and observations made about. Here, Honorable Apex Court wanted to hold back one matter and send the other back to the High Court for fresh decision. That was considered, no, this will lead to complications.
Out here, we cannot do that in any
Yes.
event. There's a common judgment
Okay, it's a common judgment.
and there's a common trial also.
Common trial.
So these issues were not taken up at the time,
It was not taken up.
Not pointed out by anyone.
because the competent lawyers all here.
All are here.
And it's appeal is a continuation of the trial.
Correct. Correct. Heard Mr. B.K. Mahajan, learned counsel for the appellant in criminal appeal 82/2018. Where are you, Mr. Anshuman?
Two,
Second
item
appeal,
two.
my lord.
And
Okay, criminal appeal 85, my lord.
and Mr. Anshuman M. Bora, learned senior counsel for the learned senior counsel for the appellants in criminal appeal 85 of 2018, assisted by Mr.
V.A. Chaudhary.
And
V.
V.A. Chaudhary.
And
And
Mr.
A.K. Ganguly.
A.K. Ganguly.
A. Ganguly.
A. Ganguly.
A. Ganguly. Full stop. Right. Miss S. Jahan. Anybody else? No one else.
No.
Mr. S. Jahan appears for additional PP, appears for the state in both the criminal appeals. The appeals have been filed against the impugned common judgment dated 16/2/2018 passed by the sessions, okay, this. Oh, he was showing his annoyance. Passed by the session judge Barpita, Assam, in sessions case number 131/14 and sessions case number 347/2015. No, comma, by which the appellants. No, full stop. Full stop. Page 164. The appellants are aggrieved by the impugned judgment dated 16/12/2018 passed in sessions case number 131 of 2014. Comma, herein after called the main case. Comma, by which the appellants herein have been convicted under section 302/149 IPC and have been sentenced to undergo life imprisonment with a fine of rupees 10,000 each, comma, in default, RI for 3 months. They have also been convicted under section 147 IPC and sentenced to undergo RI for 1 month. No, and sentenced to undergo and have been convicted and sentenced to pay a fine of rupees 3,000 each, comma, in default, to undergo RI for 1 month. Full stop. They have also been sentenced, they have also been convicted under section 148 IPC and sentenced to pay a fine of rupees 5,000 each, comma, in default to undergo RI for 4 months. Full stop. They have also been convicted under section 323 IPC and sentenced to pay a fine of rupees 500 each, comma, in default to undergo rigorous imprisonment for 15 days each. The brief facts of the case is that in person to an FIR dated, just help me with the facts of the case. And the brief facts of the case is that in pursuant to an FIR dated 16/9/2010 submitted by one MD Bahadur Ali against the appellants, comma. Satya Bari PS case number 180/2010 under section 147, 148, 149, 341, 325, 326, 354, 336, 506 IPC was registered. After filing of a charge sheet in the above said Satya Bari PS case number 180/2010, comma, in criminal appeal number, no, in sessions case number 131 of 2014 arising out of the said arising out of the said Satya Bari PS case number so comma, and a recording of evidence, comma, the appellants were found guilty and convicted of the charge and sentenced accordingly. Next para. On the other hand, where is the other FIR?
347.
Judgment para 4.
Judgment para 4.
Para.
166.
Page 166 of that.
Yes, on the other hand, just a minute. On the other hand, no, but this is 179.
We
No,
lost
we-
first in point of time, my lord.
Huh?
We lost first in point of time.
Okay, on the other hand, the so actually yours is point of time first.
First
Yes,
in
yes.
point of time, my.
So and your case,
Later in point of time convicted, my lord.
yes, but your case is 347.
Yes, yes,
My lord.
yes.
So it was registered later also.
Yeah.
My lord.
On the other hand, the FIR dated on the other hand, Satya Bari PS case number 179/2010 under section 147/149/149/341/325/326 IPC had been registered on the basis of an FIR submitted by the appellants. By the appellants,
My lord.
represented
My-
by Mr. By whom? Who is the one who?
Sirajul Bhuya, my.
He is not here. He is not among the.
He is there. He is there, my lord. I'm placing. it.
The councils.
Appellant number
No.
1.
By who is
I'm repeating.
by Saijuddin Bhuya. By appellant number 1.
Sorry,
200, page 200, my lord. Down below, my lord. Last line, page 200. Do not support the case of.
Okay, by the appellant number 1.
Appellant number 2.
2, my.
Huh?
Number 2 and number
In item number 2, my lord. Appellant number 2 in item number 2, my lord.
By the appellant number 2.
My lord.
Well, no, just give me his name. By Siraj Bhuya.
Sirajul
By
Haq-
Siraj Bhuya. By Siraj Bhuya, who is the appellant number 2 in
criminal appeal 85.
criminal appeal number 85/2018. The after a charge sheet had been filed in 347 of 2015, in sessions case number 347 of 2015, the learned trial court had by the common judgment, by the impugned common judgment dated 16/2/2018, acquitted all the accused in sessions case number 347/2015. Next para. The learned counsels for the appellant submit that the disposal of Sections case number 131/2014 and Sections case number 347/2015 by a common judgment dated 16/2/2018 by the same court by juxtaposing the evidence recorded by the prosecution witnesses and thereby convicting some of the by convicting the appellants in the above appeals, no, convicting the accused persons in Sessions case number 131 of 2014, while acquitting the accused persons in Sessions case number 347 of 2015 should be set aside, inasmuch as the same is not in accordance with the law laid down by the apex court. In the case of Nathi Lal and others versus State of UP and another, 1990 SUPP, SCC 145, State of MP versus Mishari Lal Dead and others, 2003 9 SCC 426. So, they submit that in terms of the judgments of the apex court, as stated above, the learned trial court would not have taken the evidences of the evidences recorded in both the cases for consideration and in making a common judgment pertaining to two different cases. Full stop. Next para, Miss S. Jahan, the learned additional PPSM, also submits that the learned trial court erred in making a common judgment on the basis of the same set of evidences recorded by the learned trial court pertaining to two different cases. That is Sessions case number 131 of 2014 and Sessions case number 347 of 2015. She further submits that in terms of the judgment of the apex court in A.T. Maideen and others versus the Assistant Commissioner Customs and so reported in
CRLB citation can be taken.
SCC citation is not here.
Not there.
In terms of the judgment of so and so reported in 2021 bracket 4 crimes 418 bracket SC. Which is on slightly different facts. The matter would have to be remanded back to the learned trial court for taking fresh evidence where there are common prosecution witnesses in both the cases. And directing the learned trial court to pass two sets of judgments. We have heard the learned causes for the parties. Then we'll dispose this of later, huh? So basically, that's your case.
Subject to correction, Lordship said there are two sessions case. I think there is only one, 131.
No, there are two sections.
Two sessions, please.
Acha,
Two sessions.
Two sessions.
There are page 164.
acha.
Duta section.
131 or 137.
Okay, I'll just give the judgment better. Right. We have heard the learned counsel for the parties. First up. A perusal of the impugned judgment dated so and so shows that the learned trial court has disposed of Sessions case number 131 of 2014 and Sessions case number 347 of 2015 by the same common judgment, by which the accused in Sessions case number 131 of 2014 have been convicted of the charges as stated in the foregoing paragraphs, while the accused in Sessions case number 347 of 2015 have been acquitted of the charges. Yes. Framed against them. Full stop. The two Sessions cases have been registered on the basis of two different FIRs submitted by two groups of persons, two different group of persons.
Yes.
Here we have only one sessions case, 131.
No.
At here 131, correct. But they're challenging the common judgment which disposed of both the
Both they
Sessions
got
cases.
together.
No, it's okay, judgment was common, that was wrong. But sessions case is also one.
No,
The two
Acha.
madam, have you
Had-
got the paper book with you?
Paper book is not with me, but
Then
Judgment
and
is
the
one.
charge
Judgment
payment,
is one. Judgment.
Judgment of the assessment. Page 176. 164.
164 or one.
paragraph,
164 is one.
164 at the
Judgment. Top.
okay, whatever I said.
Lordship.
A perusal of the evidence
Uh-huh.
relied upon by the learned trial court while disposing of
Possible.
Sessions case number 131 of 2014 and Sessions case number 347 of 2014 shows that the learned trial court did not record separate evidences in respect of the two separate Sessions cases,
ইয়াতে আকৌ 347 আহা নাই
wherever there were
মাতা
common witnesses relating to both the Sessions cases.
না না দেখিছো কিন্তু ইয়াতে 347 আহাই নাই
In this respect, where is the common witness? Let us see.
But a common witness,
My page 205. 205 and to be read conjointly with minor 206 minor. PW2 is common minus.
Huh?
PW2 is common minus.
205.
yes, 205.
And 2062.
2053131. Who is common? PW?
PW2 is common minus.
PW2.
Juron Ali,
Ah,
4 my lord, Tajuddin Bhuya,
4 is Sadek Ali.
Duta Tajuddin Dutas. There are two Tajuddins, my lord, difficult.
one is 14, one is
Tajuddin.
Tajuddin, one is in page 205, lordship will find in 14. PW 14 is Tajuddin. PW 14, my lord.
Yes, I've got that.
Yeah, next page,
PW2, PW14 and
PW23 minus.
23.
23.
And PW9 possibly same minor.
চান খান also PW8 নাকি চান খান
But Jharkhand, where you were, PW8 is Mamta's Begum.
no PW21 Chan Khan is there in both
21
the
is
cases.
Chand Khan, same.
Same PW8 in 347.
Just a minute. PW21 PW two Juran Ali
He's
is
also there.
PW what in the other case? What is his,
PW two in both the. cases.
Both the cases.
in both the case PW two?
Huh.
Then Tajuddin is PW 14 in one three
There are
one.
two Tajuddins, my lord, difficult to.
You don't know.
Yeah.
So with this we leave out. Okay, Chand Khan
21,
21
Khan
is
is 21.
in the other case.
PW eight, my lord.
8.
21/8.
And then the other one,
23/9, my lord.
23/9.
Even the IO has the same,
I was saying.
the IO has the same, my lord.
IO is who?
23,
24
23
and
IO.
10 same, my lord.
23 is IO.
My lord.
23 is the IO.
24 and 10
24.
same, my lord.
24.
And 10.
24 is PW
10.
PW 10, my lord.
in the other case.
Yeah, exactly.
Okay, so let us see where has he referred to PW 23 in the judgment?
Just
23
I'm
and
placing it, my lord.
23 and 9. 23 and 9 to collect.
Judgment.
Mumtaz and then 20, paragraph 33. 33 is Ratneshwar Sharma.
32.
Acha. Oh, 32 is the doctor. I think.
No, para 32. One IO Lal Chand Sikdar
Uh-huh.
as PW 23 as reports.
Yes, yes. No, this is Ayo Lanchan Chikdar. Ratneshwar, I think is same. Oh, both are same.
No, so they are saying that Lal Chand Sikdar is PW 9
Hmm.
in the other.
Hmm.
case.
My lord, there are 32.
Yes,
Hmm.
okay. That's enough. Right. What have I said?
A perusal of the evidence relied upon by the learned trial court while disposing of the sessions case such and such shows that the learned trial court did not record separate evidences in respect of two separate sessions cases. However, there were common witnesses relating to both the session cases. In this
Stop.
respect,
For example, PW 2, PW 21, PW 23 and PW 24 in sessions case number 131 of 2014 were also prosecution witness or were also PW 2, PW 8, PW 9, PW 10
Yes.
in sessions case number 347 of 2015. Para 32 of the impugned judgment dated so and so also shows that the para 32 of the impugned judgment, amongst others, also shows that the evidence recorded by PW 2 or PW 23 in sessions case number 131 of 2014 and PW 9 in sessions case number 347 of 2015 has been relied upon by the learned trial court in considering the question of guilt of the appellants. Hearing. The above facts clearly goes to show that no, before that, don't say that, listen. A perusal of the paper book and the records also shows that no separate evidence has been recorded by the learned trial court pertaining to common witnesses. In both the sessions cases. Next para. In the case of Nathi Lal and others, Supra, comma, the learned, the Honorable Apex Court has held that the fair procedure to be adopted where there are cross cases is to direct the learned judge to try both the cross cases one after the other. Full stop. After the recording of evidences in one case is completed, comma, he must hear the arguments, but he must reserve the judgment. Full stop. Thereafter, he must proceed to hear the cross case, and after recording all the evidence, comma, he must hear the arguments but reserve the judgment in that case. The same judge must thereafter dispose of the matters by two separate judgments. In deciding each of the cases, comma, he can rely only on the evidence recorded in that particular case. The evidence recorded in the cross case cannot be looked into, nor can the judge be influenced by whatever is argued in the cross case. Each case must be decided on the basis of the evidence which has been placed on record in that particular case, without being influenced in any manner by the evidence or arguments urged in the cross case. Full stop. But both the judgments must be pronounced by the same learned judge, one after the other. Full stop. Next. The judgment of the learned, the Honorable Apex Court in Nathi Lal Supra was also considered and followed, and was also considered and relied upon, was also considered and cited by the Honorable Apex Court in the state of MP versus Mishri Lal, bracket dead and others, 2003 9 SCC 426. Wherein it has been stated as follows, at page 431. Let's take it from here. Next. In the case of, wait a minute, in the case of AT, Maideen and others, Supra, the Honorable Apex Court has held that it has held that each case has to be decided on its own merit, and the evidence recorded in one case cannot be used in its cross case. The only caution is that both the trials should be conducted simultaneously, or in the case of appeal, they should be heard simultaneously. Next paragraph. As stated earlier, the perusal of the paper book and the records clearly show that while that no separate evidence had been recorded pertaining to both the sessions cases by the learned trial court. There are there are many prosecution witnesses in both the cases, in both the sessions cases. However, there are also a few common witnesses in both the cases for which separate evidence would have to be recorded, indicating that the evidence has been recorded for a particular case, for a particular sessions case. The same not having been done, not having been done, the matter would have to be remanded back to the learned trial court to do the needful stuff. Further, as required, as per the law laid down by the Honorable Apex Court, the trial court would have to dispose of the two sessions cases by two separate judgments, which has not been done in this particular case. In view of the reasons stated above, we remand both these, we remand both the matters back to the learned trial court. The learned trial court is directed to record separate evidences of the common witnesses by indicating that the evidence of the common witnesses have been examined in relation to a particular sessions case. Thereafter, after examining the witnesses, examining the accused persons under section 313, depending upon the evidence to be recorded and giving an opportunity of hearing, the learned trial court shall dispose of the two sessions cases by two separate judgments. Consequently, the impugned judgment dated so and so passed by the learned trial court so and so is hereby set aside. The appeals are accordingly disposed of.
Well, those who are on bail, you will remain on bail. Because judgment is set aside.
They are okay.
Those who are on bail.
Okay. So what we do? We let them apply there again.
Yes, because
No, but
three-
We are already on bail. Two are inside, madam. They will apply a fresh
Those
matter.
who are inside, they will apply FS there. Madam.
And the others are already on bail.
Okay.
They will remain on.
Let them be on bail. What is that?
Yes.
let them.
Those the appellants who are already on bail shall be allowed to remain on bail.
Previously.
Remain on bail. By giving a fresh bail bond. Bail bond and surety to the satisfaction of the learned trial court.
And the rest, madam, who are there, they may apply. They may apply. for
There is
the
no.
389 is during the pendency of the appeal. Now, if the appeal goes.
Because they are
that-
during trial, they are all, everyone is on bail, madam.
Acha.
Okay. The question of granting bail to those appellants who are in custody shall be subject to the decision of the learned trial court.
Highly of them. Well, these are set, judgment is set aside. Madam.
Yes.
Yes,
Judgment is set aside. Madam.
Set aside.
How much?
The conviction is set aside. Once that is
Yes,
set aside, sentence automatically. Do I have to
Fine,
say that?
fine.
Then what about the?
IA is disposed of.
Well, possibly in the
In
case,
view of the
madam,
order passed in the main appeals, the IA is also accordingly disposed of. Yes, what?
well, in possibly, my lord, subsequently 302 was added while dictating, my lord, that was possibly left out. my lord.
302?
302 was added. In the case subsequently, my lord, that part Lordship did not want. to-
I have said 302 also. He has convicted a sentence under 302. I said
Yes,
that.
yeah, that is good enough.
That
That is
good
done.
enough. That is good
All
enough.
right.
You have been convicted a sentence of
Yes.
under many sections.
My lord, it's all right. We are sorry.
302/149.
My lord, 149. Primary.
We'll just write for 2 minutes. All
My
right.
lord. Thank you. এখন নকবা।
Against conviction, my lord, where the appellants are convicted for life. So under section 302 and 149, my lord.
Just a minute. Convicted under
302, 149. For 302, they are
302/149.
my lord. 302, 149. Charge was framed, my lord, under section 326 and 148 also. That was with due course that
Charge under 320.
the charge was framed under section, my lord, along with 302 and 149, 148, 326 was also there.
148, 326.
326, my lord. And thereafter, my lord, the learned trial court, after going to the evidences and all, has
Only
had them guilty
302
under
and 1.
302 and 149. As of record, with regard to 149, there are as many as, madam, 6 persons.
6%.
Persons, accused persons, 6 accused persons.
So there, how many appellants here?
5 appellants, one was tried by the juvenile board and he was.
So there were 6 accused.
So 6 accused as of on the as part the FIR, my lord.
6 accused, one was by the Juvenile Justice Board.
My lord, he was acquitted, bleeding severely on her head and on the road, on the road. And my lord, all contradictions in the evidence, I will come, my lord, with them. PW, my lord, most important aspect is that PW4 and PW3, as per the FIR, as per the deposition, they are injured witnesses. There is no medical evidence with regard to their injury, which has been cited even by the trial court, stating that since there is no injury and no repose, so 326 is not attracted, they acquitted. My lord. So, with near my house, now my mother is at, my lord, interestingly, now my mother is in a critical condition. Critical, that is, she referred to PW4 with regard to FIR. The last line, now my mother is in a critical condition, is referred with regard to PW4. I take your lordship to PW1, page 9, deposition.
Yes.
My lord, married Mohar Ali. His name is Muhammad Mohar Ali.
Yes.
I know informant Abdul Quddus. The accused persons are my co-villager. I knew deceased Amir Ali and Malkata Sur. The incident took place in the year 2010.
But someone has died.
Yes, 2 persons died, my lord. 2 persons died.
Father and son.
Father and son, 2 persons died, my lord.
Yes.
The incident took place in the year 2010 and do not remember the date. Around 6 AM, the incident took place. It was a Ramadan month at the time of the incident. Therefore, I was sleeping in the morning. That on being hearing commotion outside, I came out of my house and came to know that Amir Ali and Malkata Sur has been killed. Then I did not know the names of Hatem Huzi, Quddus and his wife. I went to see the deceased person. Going there, I saw the body of Malkata Sur with neck cut injuries. Amir Ali was lying injured in the field of accused Amir Hassan. And then he was alive. On being asked Amir about the incident, he could not say anything.
we lifted Amir and took him to Bongalmara Hospital, but before providing treatment, he died there itself. During the investigation this case, once I appeared before the court and gave my statement and I put my thumb impression thereon. My lord, here important one part. The last fourth line, we lifted Amir and took him to Bongalmara Hospital, but before providing treatment, he died there. As per PW1, he was lifted, taken to Bongalmara Hospital, my lord, and on the way, he died, my lord. This is.
No, does not say on the way.
No, my lord.
Where does it say on the way?
He
It
lifted.
says that before providing treatment, so
No,
he could have
no.
died in the hospital.
My lord, the hospital expect has the main witnesses that the reason for my showing this is that this is something different with regard to mimosa. The person died on the way to police station. He was not taken to hospital. On the way to the police station by his son, he died on the way. And thereafter, my lord, his body was in the police station. After that, he was taken for postmortem, my lord. The reason for my showing PW1 is, my lord, you may note this point with that regard. And my lord, then my lord, the cross part. On the day of incident, it was raining heavily from the night till the morning. On hearing commotion, I came out of my house. It was around 8 AM when I came out. Till then, I did not hear any hue and cry raised by Rohila. Rohila is PW3, my lord, the wife of deceased Amir Ali and his son Sheikh Karim. I do not know as to who has killed the deceased. I saw injured Amir Ali sitting on the land of accused Amir Hassan at some 10-12 feet away from the dead body of Malketa Sur.
Who is this Amir Ali?
Amir Ali is the deceased
Okay,
Father.
father, yes.
and Malketa Sur is the son. I did not see any blood stain at the place of occurrence. I did not hear about any quarrel between both the parties, my lord. And here, my lord, PW1 has not even described, he has stated that he has not stated that he has seen PW3 and 4 or any persons in the place of occurrence, my lord. My lord, together with I go to the 164, my lord, I will take the 164 later on, my lord. Can I take the 164 of this person
Anytime.
together? My lord, I take your lordship then please. 123 of the paper. 123. On 15/8/2010, as it was day of Ramzan month, I got up at 3 AM, took my meal, and around 6 AM, I was sleeping in my house again. Then I suddenly heard from my bed some children saying outside loudly that Amir Ali and Malketa Sur had been killed. On hearing that, I left my bed and came to the road. At that, it was raining heavily. I saw some of our villagers gathering at some places. On being asked, people replied that Amir Hussain, Nizamuddin, Ruhul Amin, Nur Muhammad, and Rohima Khatun in a group had killed Malketa Sur and Amir Ali. On being heard, my lord asked. On hearing that, I went ahead. I do not remember the name of those persons. I saw the body of Malketa Sur with neck-cut injuries lying in the field of Amir Hussain. I also saw the body of Amir Ali lying at some distance on a land covered with jungle. Then I saw my co-villager Hatem Haji, Hojura Khatun, and Mumin Nisa there. Some more persons and some children were also there. I do not remember their names. Seeing some, my lord may kindly see this part. Seeing some movement of the body of Amir Ali, when I went to lift him, Nizamuddin, Ruhul Amin, Nur Muhammad, Rohima, and Amir Hussain rushed at me. Seeing them armed with dao and sticks, I fled away from there in order to save my life. 164, initially he has stated that villagers have stated to him that this person has killed those two. Subsequent in 164, he stated that when he went to lift him, all the persons rushed at him with dao and sticks. In the PW1, he has stated.
You see, the thing is, there could be many reasons, but the more important thing is, was the witness PW1 confronted with this 164 statement?
No, my lord. Or he was, my lord, no, my lord. For in the PW1.
You see, because this 164 statement
Yes.
seems to be, could have been the correct version. He may have been threatened later or something, whatever, we don't know. Whatever it may be. As per law, we'll have to look into the evidence recorded by the learned trial court.
My lord.
And if there is any discrepancy
Yes,
with the evidence, with the statement under 164,
yes,
then the witness will have to be confronted with it as
Yes.
to why he said this in his 164 and is saying this at one in his
my
evidence
lord.
before the court.
Yes, my lord. My
Then-
lord, when the one PW1 was taken, my lord, with regard to my lord, my humble submission is that, my lord, PW1 has clearly stated in his evidence, my lord, in his evidence, Fondings asks Amir about the incident.
No, madam, there is one thing. I know what you're trying to say is
Yes, my lord.
he's not a reliable witness
Fine.
because there are contradictions in his evidence and statement under 164.
164.
Now, my question to you is, supposing
Yes,
there is a evidence taken of a witness
my lord.
and there is a 164 statement
My lord.
given.
My lord,
Now, which should the court rely upon
my lord.
if the evidence, if the witness is not confronted during evidence with his 164 statement?
My lord, I agree.
Can you tell me the law?
Yes, my lord, here, my lord, I was about to answer. Huh?
Only the transcript.
Only the transcript will come, my lord. Only the.
Only the
transcript-
evidence
Yes, my lord.
recorded,
My
yeah.
lord, here one more aspect is that I am, my lord, I am understanding the query my lord has put upon. My lord, supposedly I say that generally the cross is that you have not stated the same thing what you have stated in.
Correct,
164.
correct.
Yes, my lord is about that point.
Yeah.
My lord, sometimes for the defense, putting that question is also dangerous. Because in the 164, he knew that he stated something more which he forgot as it was stripped off. Maybe, because if adding that statement.
Or maybe
yes,
everything was fresh in his mind and he said the truth there, but he's not
my
saying
lord,
everything.
The law says about the deposition part.
Huh?
The law is with regard to the deposition, what he have stated in deposition. Because,
Where is the law? Show me the law.
my lord, with that aspect, I have to find this.
Anyway,
Yes,
you
my
have to
lord,
find.
that
But
one I will.
no, if you have got to find that, because you said the law states. If you said the law states, that means you must have read it all.
My lord, if 164 is there, and if it varies with the deposition letter, my lord, generally the deposition is taken into consideration, my lord. And one more thing, my lord, here, with regard to that aspect that my lord has stated, if that would be asked, that might be dangerous to the defense also.
That is a different thing.
That is.
That is a different issue.
Yes, my lord.
The issue is if the witness is not confronted with his statement, contradictory statement, then whether that 164 statement can be taken into consideration.
Generally, mostly the deposition is taken into consideration.
Only the evidence.
Evidence
So
is
there's
taken-
no point going into this aspect.
No, yes, my lord, yes, my lord, that is there. My reason of showing is.
I
with regard to
understand your reason.
Reliability of witness.
Yes, but then unless you confront him, you cannot take that stand.
Yes, my lord, that is true. But I am showing with regard to, since this person is PW1 and his 164 was taken, my lord, I'm showing with regard to the reliability of that part.
No,
Only
no,
on that basis.
reliability will only
And
come when
if
you
it's not
confront him.
Considered also, my lord, this will not affect my case because he's not an eyewitness.
Yes,
also.
okay, next.
And
So let-
one more thing, my lord, my reason of showing this PW1 was that he's not an eyewitness. He have not seen PW3 and 4 on the place of.
So
Yes.
how does it? So it's not a material witness.
PW2, my lord. I take your lordship to PW2. Abdul
PW2.
Qudus, my lord.
Yes.
Accused Amir Hassan is my uncle and rest of the accused persons are my cousins, son of uncle. Deceased Amir Ali was my father and deceased Malketasur was my brother. The incident took place in the morning on 15/8/2010. At that time, I was freshening up at the courtyard of a house after getting up. Then I saw that accused, my lord may note down, then I saw that accused Idris Ali was plowing the land belonging to accused Amir Hassan, and the rest of the accused persons were sitting on the bank of their pond. My lord may note down this one. At that time, I went to open my shop situated at Sariali. Then my younger daughter Tasmina followed me in a run and informed me that quarrel had taken place at the cultivation field belonging to my uncle. Thereafter, I proceeded. My lord may note down this point. Thereafter, I proceeded and saw that my stepmother, Rohima Khatun, not accused Rohima Khatun, was coming to our house holding her bleeding hand. On being asked by me, my stepmother told me that the accused persons had killed my father and younger brother. I saw that my brother had already died, but father was alive. My another brother, my lord may note this also, Sheikh Farid was also lying there in an injured state. Then I took my stepmother, father, and brother Sheikh Farid to Bongalmara PS in an auto rickshaw. My father breathed his last on the way to the police station. My lord, as I have noted there. Then I sent my mother and brother Sheikh Farid to Lokhimpur Civil Hospital with Sahed Ali for their treatment. Firstly, I verbally informed the police station about the incident, whereupon police went to the place of occurrence and brought the dead body, my brother, to Bongalmara PS. Later on, I lodged a written ezahar with the Bongalmara PS before the dead body of my brother was brought to Lokhimpur Civil Hospital for post-mortem examination. When inquest was held, my lord, this is exhibit 1. When inquest was held on both the dead bodies, I put my signature on the inquest too as witness, exhibit 2. My lord, he is pros, my lord. My lord, before proceeding to pros, with regard to the evidence, the 3 aspects, my lord, is important. The last line, then I saw that accused to attract 149 was this statement. Then I saw that accused Idris Ali was plowing the land belonging to accused Amir Hassan, and the rest of the accused persons were sitting on the bank of their pond. First point, my lord. Then, my lord, the 5th line is important. Thereafter, I proceeded and saw my stepmother, Rohima Khatun, was coming to our house holding her bleeding hand. And the Sheikh Farid was also injured as per his version. And then, my lord, that they were taken to the police station where he breathed his last, my lord. My lord, the cross. I did not witness the incident. My lord, I did not state that when accused Idris Ali was plowing the land belonging to Hassan Ali, the rest of the accused persons were sitting on the bank of their pond. My lord, evidence is in the cross he has stated that I did not state. My lord, I did not state that when Idris Ali was plowing the land belonging to Hassan Ali, the rest of the accused persons were sitting on the bank of the pond. Tasmina is now aged about 10. She did not inform me amongst whom the incident had taken place. On my arrival at the place of occurrence, I saw my brother Malketas's dead body lying there and witnessed Mohar Ali carrying my father to near the house of my stepmother Rohima. I don't remember by what time I reached the place of occurrence. My shop situated at less than 1 kilometer away from the houses of the accused person and that of my stepmother. I found injured Sheikh Farid on the road in front of their house. My lord. My lord, here with regard to this statement, later on I will take, my lord, I take your lordship to the other deposition. The house of Rohima. This Rohima is the second mother, my lord. The house of Rohima was there nearby, my lord. And as per this person, I found injured Sheikh Farid on the road in front of their house. And the occurrence took place in a paddy field. I came across my stepmother near the house of Abdul Jalil. He stated that he came across his stepmother there. I cannot say the exact place where the incident actually took place. I cannot say if I verbally informed the Bongalmara PS about the incident. I have forgotten by what time I lodged the Ezahar with the Bongalmara PS. I studied up to class 9. In the Ezahar, I did not mention the name of the person from whom I came to know about the incident. I did not mention in the Ezahar that the incident had taken place on the land belonging to Amir Hassan. My mother died about 25 years back. Subsequent to the death of my mother, my father remarried my stepmother. My stepmother has 6 sons and 3 daughters. We are 3 brothers and 3 sisters from our mother's side. I am the eldest. This is Malketasur was my immediate younger brother, and Abul Hussain is the 3rd amongst the brothers. It has been about 15 years since I started living separately from my father. It is not a fact that following a quarrel with my stepmother, Abul Hussain too has been living at village Sonapur Reserve about 4 kilometers away. It is not a fact that while adducing evidence in the case of juvenile Nur Muhammad, I stated that my mother Malketasur has been hacked in the neck and left on the road. I cannot say how many injuries were there in my father's body. I also cannot say if there was any injury on Malketasur's body other than the cut of his neck. I noticed that half of my brother's neck was out. Blood came out of my stepmother's head and her clothes got stained with that blood, but police did not seize her blood-stained clothes. I did not notice injury on my brother's Sheikh Farid's body. My lord may remember, he stated he has seen the injury of Sheikh Farid. Now he is coming. I did not notice injury on the body of my brother Sheikh Farid. My lord, it is not a fact I did not inform police anything verbally. I stated in juvenile court that I saw my brother Sheikh Farid lying on the paddy field after sustaining injury. It is not a fact I did not say to police that I came to know about the incident from my stepmother. When I found my father, he was not in a position to speak. It is not a fact that I stated in juvenile court that my brother Abul Hussain lives at a distance of about 3 kilometers away from the house of my father. It was the time of fasting at the time of incident. It was drizzling at the time of incident. It is not a fact that I did not state to police that my daughter Tasmina informed me that quarrel took place in the field. It is not a fact that quarrel often took place between my deceased brother Malketasu and my stepmother. It is not a fact, my Malketasu was unmarried, my father was aged about 65. It is not a fact that my stepmother and her sons altogether killed Malketasu, and that when my father resisted them from assaulting Malketasu, they killed him too. It is not a fact that today I have adduced false evidence and I lost the Azahar bringing false allegation. My lord, with regard to PW2, my lord, my lord, with regard to PW2, my point was that, my lord, he stated he has seen this persons lying on the, sitting on the pot. In the cross, he has stated, I did not state something. Thereafter, he has stated clearly twice in the evidence that he has seen blood oozing out of his mother and injury in the safe for its body, my lord. Thereafter, he clearly stated that I have not seen any injury in the body of safe for it, my lord. This is, and the most important part with regard to PW2 is that he has said twice, my lord, the way on the road he has seen his mother holding her head coming to him towards the road and stating that she was injured, my lord. But with due course, my lord, will see with regard to the evidence of that mother. I take your lordship to PW3, who is the eyewitness, considered as eyewitness. The page number 16. The accused persons belong to our family. This is Amir Ali was my father, and this is Malketosu was my elder brother. It was an incident that took place around 5:30 a.m. on 15 August 2010. And my lord, this is important. At that time of the incident, I was plowing in our field. He stated that he was plowing in the field. At that time, my elder brother, Malketosu, was going to his house from town Sareli. While he was coming towards a road across the field, Nur Muhammad, the juvenile, hit my elder brother on his head with a stick from behind. My brother fell on the ground. As soon as he fell down, Nur Muhammad pressed his head and accused Rohima Khatub grabbed his legs. Then accused Nizamuddin hacked his head. Having seen the incident, my father went in a run from our house. At that time when he was coming, accused Amir Hassan hit my father on his head with a lathi. My father fell on the ground. Then accused Rahul Amin hacked my father on his buttock with a dao. Having seen the incident, I went in a run towards my father. Then accused Amir Hussain hit me on my head. I became senseless and fell down there. After 10-15 minutes later, I regained my senses and saw that my elder brother Kudus Ali was coming from the house. I saw that my mother was bleeding from her head. When I asked my mother, she said that accused Ruhul Amin had blown her head with a dao. Later, my elder brother Kudus took my mother, my father, including me, to Bongalmara PS by a tempo, and my father died on the way. My elder brother Kudus took me and my mother to Lokhimpur Hospital for treatment. My lord, did cross, my lord, here everything, it is not a fact. He has denied that one. It will come, my lord, may come to page 18. This part, the first part was it is not a fact. Then page 18, second part. No quarrel took place on the day of the occurrence. It is not a fact that no any medical treatment was administered to me since I had not sustained any injury. My lord, others are the common part with regard to the issue, my lord. My lord, the PW3, who is considered as eyewitness, my lord, he has given his 164 also.
Has he been confronted? with
Yes,
it?
my lord, let me, my lord, with that one.
Look, if he's not confronted, there's no point going there.
My lord, with regard to, with due respect, my lord, with regard to my submission, my lord submission with regard to the confronted part, my lord. Generally, my lord is aware with regard to section 1133, my lord, of the Evidence Act, my lord. even sometimes the accused 164, my lord, is taken, sometimes it is not confronted here, my lord, that is I admit with regard to the defense. But my lord, with regard to variations, with regard to its reliability, my lord, that is required to see when that person is an eyewitness and an immediate relative also. And with that, my because my lord, 164 was taken, my lord. Here, my lord, one person was Ruhul Amin, accused person named Ruhul Amin, my lord, by the PW3 has stated in his evidence that he has hacked his father on his buttock with a dowel. 164, he has not stated anything of that aspect, my lord. There are, my lord, no injury in the body, my lord. So, my lord,
He has not
Yes.
exhibited 164 statement.
my lord, yes,
Whether,
Perhaps by police was exhibited.
yes.
whether 164
No,
statement was exhibited.
Exhibited, I
By
lord,
the IO.
PW9, my lord. My lord, no, my lord. No, my lord. Exhibit 164, my lord, it's. No, my lord, it's not exhibited. It's not exhibited, my lord.
So whether it can be used for,
Yes, they have from the part of defense. This is not exhibited. They have not even exhibited. the-
neither you have confronted the,
In some of the depositions, I have, my lord, seen that it has been confronted, but most of the part, the defenses, my lord. No, it's not.
Ms. Jahan, what is the judgment regarding that,
Contradiction.
huh?
Contradiction.
Yes, contradiction.
VK Mishra. That is 2015.
2015, volume 9.
Huh?
See,
Huh?
2015, volume 9, 60.
2015, volume 9,
Hmm,
SCC
588.
588.
588, yes.
588. What is the party's name?
VK Mishra and others versus State of Uttarakhand.
VK Mishra
V
and others
versus State of Uttarakhand.
versus State of Uttarakhand.
The paragraph was, I'll place it,
Yes.
that it needs to be confronted. 26,
16 to 19.
Para?
16 to 19. 16 to 19.
it's 18 is the relevant paragraph. 18. When it is intended to contradict the witness by his previous statement, attention of such witness must be brought and then it needs to be placed before the police.
Oh, you are reading from Manupatra or something?
I'm
It's
taking
different.
it out from
Out in
Manupatra.
section 1, how does the paragraph start?
Oh, paragraph was different. I think paragraph 20 on the last occasion when during that Hemaji case, I placed it. Paragraph 20, perhaps it starts with under section 145.
No, that is 19.
Oh, 19, acha. When it is intended to contradict the witness by his previous statement reduced into writing, the attention of such witness must be called to those parts of it which are to be used for the purpose of contradicting him before the writing can be used. While recording the deposition of a witness, it becomes the duty of the trial court to ensure that part of the police statement with which it is intended to contradict the witness is brought to the notice of the witness in his cross-examination. Here only 161, not 164. 164, I think Kehar Singh's judgment was there. The attention of the witness
But
is drawn.
164 is also a previous statement.
It is also a previous statement
It can be used for the purpose of contradiction
Contradiction.
also.
and corroboration, both. 161 not corroboration, 161 only contradiction. If the witness admits the part intended to contradict him, it stands proved and there is no need to further prove. If he denies having made that statement, his attention must be drawn that statement and must be mentioned in the deposition. By this, it was brought on record. Then after that, it has to be placed before the IO. This is what the procedure is.
Now, what is your submission? Why PW3 should not be relied upon?
My lord, that is, there's lack on the part of the defense, I think,
In fact, 164 statements are not exhibited.
not exhibited, my lord, interestingly,
They were simply brought on record.
both on record.
I don't see any exhibit number here.
No exhibit, not exhibited. Because had it been exhibited, it would have been reflected, it's not exhibited. Only the FIR was exhibited. Even the witness, it has stated, though my lord, it was not exhibited, my lord, but the witness, it is not a fact that I stated before police and magistrate that the incident took place over the matter of plowing in the field. Defense, it was not exhibited, my lord, that is fair. But statement is that it is not a fact. There is a denial that I have not stated before the magistrate. There is the, but it was not exhibited, my lord. The 164, my lord, is now the admitter is not exhibited, but the deposition of it was brought on record, but it was not exhibited. The defense has might have questioned it because he has stated that he has not stated this before the magistrate, before the police and the magistrate. So he has referred about his 161 and 164, but the same was not exhibited, my lord, by the prosecution, my lord. So
So what is to be done?
cannot be taken into account because if it's not exhibited, but my lord, defense has put his question, or else this should not have been there. It is not a fact that I stated before police and magistrate. Police means 161, magistrate 164, it's clear. But the same was not exhibited.
Yeah, next.
My lord, here with regard to, my lord, I would like to submit that, my lord, there are no blood stains was found, my lord. No seizure of any clothes, no seizure of weapon. My lord, interestingly, that was also not exhibited. There was cover of some LS cover not produced before court, my lord. There was some
Let us read PW4.
PW4, my lord. My had the 164 be exhibited, these complete variations in their statements.
You see, but one thing is, his husband died.
My lord, that is in PW4, who is
Well-
the wife, my lord, most contradiction was there. But she stated the incident occurred at the campus of her house. She stated this person came
Look,
inside my house.
Look, these persons, what are these persons? These persons are very poor persons, I think. I mean, they are, I mean, not poor, I mean, they are cultivators probably.
Culti people, all are.
And most probably they are unaware of the English language. I think.
My lord, it's in Assamese, it was translated to English.
Okay,
It was in
Because-
particular,
because-
it has been
yeah.
translated, like a paper book was.
evidence was made in.
Yes, my lord, in Assamese. My lord, PW4, now though this part has, my lord, PW4 in her 164 has stated the incident occurred, these persons came
Forget
inside my house.
Forget 164. If it's not exhibited, if they're not confronted.
Confronted, my lord, that is true. That will lead to a different aspect to my case, my lord. That will lead to a different.
But are you an amicus or
No, my lord.
you're the apparent counsel?
Nine. The thing is that if The same was not exhibited, but the question was put by the defense. That is the thing, exhibited, that was not exhibited. That was something like on the part of prosecution. Generally, defense, generally they don't. Then in this regard, my lord, I pray that my lord, with this, let me assess a little bit of depth. My lord may take up this matter on any other day, because if I proceed with my deposition only living beside the 164, it might bring, because I'm all prepared with that aspect. I have not seen whether it was my lord. I have
No,
not-
no, so you'll have to go without it. If it is not, if they're not confronted with it. When there is, it's
No.
not exhibited, then you'll have
I
to go by
wanted
what
to
is
find,
there.
I wanted to find decision only one with one aspect. When certain cases, in this case, my lord, in certain, my lord, with due respect, by senior Juliba will be knowing that part. When the bench was taken by Honorable Justice Pujaburwa sir, he had went even to the extent of Juliba 161 statements also to certain extent. While considering the credibility, I have argued in some cases as amicus, I forgot those part also. So my lord, I wanted to see only with that aspect that when 164 is not exhibited, but it's a part of the record, my lord, then in that case, since it is with regard to life imprisonment, I also want to be clear in that aspect, my lord. Because if I proceed, my lord, I am prepared with contradictions part. Because if we take out the contradiction, there was no eyewitness. There was no eyewitness. All the injuries are different. The injury sustained and the PO injury, PO is different. My lord, I take,
Death remains.
that remains. But the question,
So-
who killed?
So, yeah, the
The
question
question
remains.
remains who killed,
You
because
see, now you are worried about the nitty-gritty of injuries. But the death is there right in front of you. What have you got to say with that?
my lord,
With regard to the death of those two
Yes.
persons?
this is the thing, my lord. One of the witnesses stated that there was fight between the family members before the incident.
Yes, it appears so.
Yeah.
It appears that they are all family related. It
Really?
appears they are all related members.
No,
Yes,
in the-
probably, most probably fighting over land.
no, there was, he has not stated that part. He has
Not
stated,
stated, but since we are speculating,
no,
even we are
one-
speculating.
One witness that I have not gone, my lord, till now. That witness has stated there was a fight between deceased Malketasur and with their own brother before the incident. There was one witness in the PW, my lord, I think PW 5 at page 24. He has stated.
You
my
see,
lord,
there's no point adjourning the matter, madam. Just
My lord,
because just because you see something that do not go as you wish it to go,
my lord,
doesn't mean that it should be adjourned.
my lord.
Yeah, okay.
No, my
So,
lord,
so we'll carry on here.
Yes, my lord. Then, my lord, with regard to PW4, my lord, the eyewitness, Rohima. The accused persons are the family members of my husband. My lord, page 20. The accused persons are the family members of my husband. This is Amir Ali was my husband, and this is Malketasur was my son. I do not remember the date of the occurrence. The incident took place in the morning. The incident took place on a road across the field. Malketasur came along the road across the field. Asked accused Idris why he had been plowing on the land.
Okay, land problem.
Land. Yes. I'm silent. 164 she said they came inside the house with all those things, killed him there. But
The fact remains that there was a killing.
killing was there, but the question, my lord, if all would have been there, the question would have been whether these persons killed or Rohima and Sheikh killed them.
Let's see.
Malketasur came along with the accused Idris why he had plowed on their land. Then Nur Muhammad hit him on the head with a lathi. When he fell down, Nur Muhammad grabbed his head, Rohima grabbed his legs, and accused Nizamuddin hacked his neck with a knife. Then my husband Amir Ali arrived there, and then accused Amir Hassan hit him on his legs. Accused Ruhul Amin hacked my husband on his head and waist. Meanwhile, my son Sheikh Farid arrived there and accused Ruhul Amin hit him on his neck and legs with a lathi. Having seen the incident, I reached there and then accused Ruhul Amin also hacked me on my head with a dowel. Then I became senseless. Later, I regained my senses at Bongalmara police station. According to PW4, my lord, I'm on now with the PW4, she stated that after seeing the incident, she became senseless. And after being the Sheikh Farid arrived there and accused Rahul Amin hit him. She has seen Sheikh Farid being injured by Rahul Amin on his neck and legs with a lathi. And when she reached there, Rahul Amin hacked her on her head with a dowel and she became senseless. As per the version of PW3, my lord, as per the version of PW3 asked his mother, how you got injury? She replied, when I asked my mother, she said that accused Ruhul Amin had blown her head with a dowel. According to PW3, he came later, asked mother. According to PW4, he came later, she was already senseless. According to PW2, she was holding her head on the way, going on the road. On the road, he met her. He has stated twice in the evidence. He has met her, and then she stated that this was the incident occurred with me, my lord. Now, my lord, I take your statement to the cross at page 21. The incident took place on the road leading to our land. The distance between the places where Malketasu and my husband was lying might be around 25-30 feet. Earlier, when I recorded my statement before the, my lord, even see also. Earlier, when I recorded my statement before the magistrate and police, I stated that the place of occurrence was within the premises of our house. Then I did not state that. My lord, I did not state that. Nur Muhammad hit Malketasu on his head, as a result of which he fell on the ground. And then I did not state that Rohima grabbed his legs, accused Nizamuddin, hacked his neck with a knife. Then my husband, Amir Ali, arrived there and then accused Amir Hassan, hit him on his leg, accused Rahul Amin, hacked my husband on his head and waist. Then on seeing the incident, I went there and accused Rahul Amin also hacked me on my head with a dowel. It was not exhibited, but defense has put his questions in which she has stated that at that time she has not stated before the magistrate and police that the place of that she has stated that the place of occurrence was within the premises of her house. She has stated that I did not state that time that this person's killed, this person's killed, and all those things, my lord. But it's not exhibited, but she has put that point in. In the PW5, my lord.
For contradicting a witness, the statement need not to be exhibited. 164 statement need not to be exhibited, but it has to be, witness has to be reminded that you stated so and so before magistrate.
Yes.
Here you are stating differently.
Yeah. Then this would cover, my lord. This PW4 was reminded. She stated that.
But you have to again put this to the IO or the magistrate.
I know that was done. That was done. PW9 is the IO. IO has stated all those things that he was not stated all those things. In PW9, my lord, if I will take with time, my lord, PW9 has stated.
164 may be. 164. Whether the magistrate who recorded the 164 was examined as a witness in this case?
No, my lord.
No.
No.
Then perhaps the ones, unless 164 is exhibited, whether it can be used for.
My lord, as my lord has just stated with regard to one aspect, my lord, this part so I'm not totally clear, but as my lord has stated that the witness to be reminded of that part. Here she has stated earlier when I recorded my statement before the magistrate and the police. My lord, page 21, the last paragraph. Yes. Page 21. Page 21. Earlier, when I recorded my statement before the magistrate and police, I stated that the place of occurrence was within the premises of our house. Then I did not state that. I did not state that, and all those she has stated, my lord. She was reminded with that aspect, my lord.
Where?
Page 21, my
Yes.
lord, the last
Yes,
paragraph. Earlier, when I recorded my statement before the magistrate and police, I stated that the place of occurrence was within the premises of our house. Then I did not state that Nur Muhammad hit Malketasu on his head, As a, she has stated that all those injury, but she has not stated that.
Let us see 164, where is it page?
Yes. Page 116. My lord, page 116. May I read, my lord? Some days ago from today, do not remember the date. My lord, interestingly, it was only 9 days. Around 6 a.m., Nizamuddin, Nur Muhammad, Rahul Amin, Amir Hassan, Idris Ali, and Ruhul Amin's mother, Rohima, entered into our campus. They were armed with sticks, machete, dao, sword, and kukuri. Nizamuddin hacked in the neck of Malketesur with a sword. Rahul Amin and Amir Hassan killed my husband Amir Ali by dealing blows with dao and stick. When Nur Muhammad was holding Malketesur, then Nizamuddin cut the neck of Malketesur. Idris Ali dealt blows on my head with stick. As a result, I sustained injury on my head. Ruhul Amin and Idris Ali assaulted my safe with stick. Ruhul Amin dealt with 2 machete blows on my head. I became senseless. This was a 164 statement. And the deposition, my lord, she has not referred any name with regard to Idris Ali, with regard to the exaggeration made in the deposition that Ruhul Amin hacked me or hacked my husband on his neck and
You see, in her evidence,
my lord.
she has said that Nizamuddin hacked his neck with a knife. Now, when you look at page 116,
My
he
lord.
again says
Yes, my lord.
Nizamuddin hacked the
The
neck
neck of
of
Malkit.
Malak. So there's nothing, there's no
Yes.
contradiction here. There is a contradiction.
My lord, my lord here, then my lord, the every other part also has to be seen, my lord.
Yeah.
My lord, here is say, Ruhul Amin and Amir Hussain killed my husband Amir Ali by dealing blows with dao and stick, my lord. And here,
Correct. And again, out here, Rahul Amin. Out here also, in
He
page
said-
21, he says Rahul Amin.
Ruhul Amin hacked my husband
Yes.
on his head and waist.
Rahul Amin and so it is there.
Uh,
Evidence is there.
My lord, when with regard to specific, my lord, here my submission, my lord, my reason of doing 164 with the PW4, my lord, is that, my lord, there are contradiction with they are specifically stated that this person has hacked this person at this position in the deposition, my lord, and even in the 164 also, and even those injuries do not tally even with the TM report also, my lord. And my lord, here she has made this Idris Ali dealt blows on my head with stick. In deposition, Idris Ali is totally absent. She states that Ruhul Amin has assaulted her son Sheikh Farid with sticks. That is not even stated by Sheikh Farid, neither by the in PW4 by the Rohima Khatum, my lord. And she has stated that Ruhul Amin dealt 2 measured blows on my head. There was not even a single injury report with regard to her injuries also, my lord. With regard to the injuries of PW3 and PW4, they were given multiple opportunities to bring medical reports. Not even a single medical report
You
was
see,
rendered.
Madam, it depends upon the nature of injury.
My lord, it
You
was,
see, when you say injured, it doesn't have to be a very bloody injury.
my lord,
If you get a small hit on a head or neck or something, and if it doesn't cause very much swelling or cut, it's still an injury. So it depends on the type of injury. Did you confront them as what type of injury?
my
it was?
lord, she has stated Ruhul Amin dealt 2 machete blows on my head, my lord.
Machete blows, it can be, you see, machete blows, it depends. It can be the blunt side, it can be the pointed, the sharp side. So it depends upon the force of the blow.
My lord. Idris Ali blows on my head and it is as I sustained injury on my head. My lord, she has even stated she went to the pool. The blood was oozing out of her. That was stated by one of the evidences, my lord. One of the, in PW2 has stated that blood was oozing out of her. My lord, even she has stated, my lord, may kindly see page 21. Ruhul Amin also hacked me on my head with a dao. Page 21. Page 21, the first paragraph, last 4th line, my lord. Ruhul Amin also hacked me on my head with a dao. My lord, after hacking, how cannot be trying to him?
Why not? It depends. You see, have you seen persons who are hacked with the Dow? There are persons who hacked 17 times with the Dow, 18 times with the Dow. It depends upon the force of the Dow. It depends upon which side of the Dow they were hacked with. It depends. There's a lot of, it's very subjective.
My lord.
Hack doesn't mean that you straight away there has to be a cut on the skin. Nothing like that.
But,
It-
my lord, I admit that part, but since one of the witnesses stated blood was oozing out of her, my lord. One of her own son has stated blood was oozing out of her. And so I take to the line of my lord that since blood was oozing out of her. And since he has stated she was hacked on her head. So I take an inference that medical might be there. There was not, even the trial court has, my lord, stated after going to all the evidence, 326 was discarded on the ground that no medical injury report was there, no injuries was there. So, my lord, with regard to the credibility of the witness, my lord, if I only take the depositions, my lord, and I don't go to the exhibits as my lord has stated, I only go to the PW3 and PW4. PW4, my lord, how can this, as now it has been commonly used as the word star witness or sterile witness, my lord, she has stated in her deposition, that she has seen this incident while at the field. In her cross, she has denied and she has admitted that before the magistrate, she has stated the incident took place in the premises of her house, and she has stated that I did not state this. She has admittedly here stated that I did not state this. So immediately her point of eyewitnesses, if we take the deposition of PW4, also it goes, my submission with it. And my lord, in PW4, interestingly, all the witnesses stated one point only, no quarrel took place on the day of occurrence. Even PW4, page 22, last second line, no quarrel took place on the day of occurrence.
You see, you don't have to have a quarrel. When by your very act, you're plowing the land of the other person. What more
No, my lord, because
instigation or
in the evidence, he has
Yeah.
stated multitude came along the road across the field, asked accused Idris why he had plowed on their left. Then thereafter the incident took place, my lord. My submission is that, my lord, with this aspect, my lord, she was not an eyewitness to the incident with regard to PW4, because in her own evidence, if we don't take her exhibits and all those own evidence itself, she in her deposition has stated very clearly, and thereafter in her cross, my lord, had she stated everything I did not state, then I could have understood that, my lord, she might not have understood the language. But, my lord, in the last paragraph of page 21, she first stated that earlier, she clearly stated, yes, earlier I stated this. And thereafter, she stated, I did not state this. Means, my lord, she was completely aware with regard to the questions being put up by the defense to her, my lord. My submission with regard to page 21. Had been everything is, I did not state.
So what is that word used? One institution or something. If you follow, when you get angry and that is the result, that institution is the word. Same thing. What is the difference between a campus and the there might be a little bit of the way it's without the basis of video advanced that would be there. There's no campus. What happened during 313? What is your
There
explanation
was
to all?
denial. See, they have not adduced evidence and there was denial. 313. They have stated, they have denied to the questions in 313.
They have denied, they said that you had assaulted so and so, so and so
Yes,
on his legs, it is false, everything is false.
there's no, generally, they have stated, I will not, I am innocent, the case is false. Because they were aware that the case was false, my lord. Because the eyewitness with the incident was 2 persons, my lord. And these 2 persons has not sustained any injuries. As my lord, we have to go to that inference only because no medical was submitted. Since it is not submitted, my lord, we have to take that inference. And even 326 was discarded by the court on that ground itself.
No, we're not, what about the death?
My lord,
What about the death?
my lord, that is the, but it is the 2 persons has stated that this death has occurred. Whether those 2 persons can be considered as eyewitness, my lord.
Okay, any citation, anything? Nothing.
Nothing, my lord.
That's, yeah, I think that's, anything else you want to add?
My lord, and with regard to the injuries, my lord, with regard to page 25, the injuries, my lord, the injuries are more than that has been described by the both 2 eyewitnesses, my lord. And my lord, and one more thing is that the investigating officer,
Which eyewitness will count the
My
number
lord,
of
no.
blows?
my lord,
There are around 4-5 persons hitting blows. 1, 2, 3, okay, 5, 6, 7, 8, 9, 10. Who's got the time for that?
my lord, my just as
Who
in-
does that?
And my lord, the IO during his process stated, I have not found any intention or motive of the accused persons to commit the alleged murder of the deceased. But my lord, this was the IO person at page 33, my lord. The IO was put to cross with regard to the questions put before PW 3 and 4. And he has stated that those were not stated before him, my lord. My submission is that, my lord, with regard to PW 3 and 4, my lord, they are not to be considered as eyewitnesses because if only their deposition is taken into account, their deposition in evidence and cross is complete. PW 4 is completely different. And PW2, my lord, with regard to the credibility of PW3, my lord, his and PW4 is different. And the other persons, PW1 and PW2, has stated that they have seen these persons at this position, not at the place of occurrence. Those persons also came to the place of occurrence. Neither of the persons have stated that neither of the other witnesses have stated that they have seen PW3 and PW4 at the place of occurrence, my lord. And there was no injury within the body. So having been such an incident and no injury in the body of PW3 and 4 is also creates a doubt, my lord. So my lord, my prayer is the benefit of doubt may be given, my lord, to them.
Yes, madam.
Now here, I would still say that 3 and 4 are the eyewitnesses in the case. I'll first deal with 4. And the contradiction that has been pointed out with regard to 64 or 61, 161 or 164. I see that actually contradiction is not there as far as the assault is. Assault was committed. Because in 161 also she had said that. The statement that she made before the trial court that I did not state, it is only in respect of the first part of the incident. That I'll just read out, Lordship will see, PW4 Lordship can take up first.
Before you say that,
Lordship.
you see this VK Mishra judgment is with regard to a police statement. Where is the anything with regard to 164?
164, the other day I had placed one. This is, there also it is said that it needs to be confronted to the accused, otherwise it cannot be used.
Yes.
This is
Give us
there.
that.
This is Lordship will find this. This is 1980 volume 2 SCC 84.
84.
Yes, 80 volume 2 SCC 84. Dhanabal versus state of Tamil Nadu. 80, maybe the book is there in the Almira. Because on the last occasion, book was there.
Tara,
Paragraph, Lordship, the
is
paragraph.
that Manupatra again?
Manupatra, but then we'll take out the book. Here it is said. Page number, what is it? Paragraph 13. Page number 84. Paragraph here it is 13.
Paragraph?
Lordship will start from paragraph. It went on to say, paragraph 7, Lordship will see. We have been taken through the relevant evidence of
Yes.
the witnesses, their statements under 164, and the evidence given by them in the committal court, which was transposed to the record of the sessions court under 288. Before considering the law raised, we find that the plea has to be accepted. Lordship can skip that. This is in respect of this particular case. 288, Lordship may not. Then Lordship will go to reliance was placed on Tara Singh's case, 51 Supreme Court, wherein it was held that evidence in the committal court cannot be used in the sessions court unless the witness is confronted with his previous statement as required under 145 of the Evidence Act. The court observed, the Lordship got the paragraph? Yes. The court observed that if the prosecution wishes to use the previous testimony as substantive evidence, then it must confront the witness with those parts of it which were to be used for the purpose of contradicting him, and then only the matter can be brought in as substantive evidence under section 288. On the facts of the case, the court found that all that happened was that the witnesses were asked something about their previous statement and they replied that they were made under coercion. It does not appear that the entire previous statement of the witnesses were put to them and they were asked whether they in fact made the statements. Then paragraph 13, the second legal contention raised by the learned counsel was that the High Court was in error in taking into account the statement recorded by the witnesses from the witnesses under 164 of the CRPC in coming to the conclusion that the evidence given by them in the committal court could be relied on. The High Court stated, we are satisfied having regard to 164 statements of 3 to 5, that the statements given by those witnesses before the committing court are true and could be relied on, and proceeded to observe that as there were statements admitted in evidence under 288 of the CRPC, then the evidence of one witness before the committing court is corroborated by that given by others. Mr. Mullah, learned counsel, submitted that a statement recorded under 164 indicates that the police thought that the witness could not be relied on as he was likely to change and therefore resorted to securing a statement under 164. The statement thus recorded cannot be used to corroborate a statement made by the witness in the committal court. In support of this contention, he has relied on this. Then Lordship will see the court observed that the endorsement made is not proper but declined to infer so and so. Lordship can skip this part. In the middle portion of it, what I can see, during the investigation, the police officer sometimes feels it expedient to have the statement of a witness recorded under 164. This happens when the witness to a crime are closely connected with the accused or where the accused are very influential and which may result in witnesses being gained over. 164 statement that is recorded has the endorsement of the magistrate that the statement has been made by the witness. The mere fact that the police has reasons to suspect that the witness might be gained over or that it was expedient to have the statements recorded by the magistrate would not make the statement of the witnesses thus recorded tainted. If the witness sticks to the statement given by him to the magistrate under 164, no problem arises. If this witness resides from the statement given by him under 164 in the committal court, the witness can be cross-examined in his earlier statement on his earlier statement. But if he sticks to the statement given to him under 164 before committal inquiry and resides from it in the sessions court, The procedure prescribed under 288 will have to be observed. It is for the court to consider taking into account all the circumstances, including the fact that witnesses had resiled in coming to the conclusion as to whether the witnesses should be believed or not. So the fact remains, Lordship will see, again, paragraph 14, section 57 of Evidence Act makes it clear that the statement recorded under 164 can be relied on for corroborating the statement made by the witnesses in committal court. The court has expressed its view through the statement made under 164. It is corroborative, what has stated been earlier. The High Court was right in relying on the statement of the witnesses under 164 as corroborating their subsequent evidence before the committal court. Lordship, what I find is it has to be confronted. That statement has to be shown to them. If they stick to that, it will be considered as a corroborative evidence. And if they resile, the end of the matter. It cannot be used. Here, PW4, she had stated that police had produced me in the court and got my statement recorded. So she had admitted that she made her 164 statement. And I put my thumb impression. So then she said, earlier when I recorded my statement before the magistrate, I stated that the place of occurrence is so and so. But as far as contradiction as to the bidding part is not there. I've checked 161 statement. Only difference is that both the witnesses have stated that that Idris was, Lordship will see, in her examination in chief, she had said all this, who had bitten up whom, with what, at what part. In her cross-examination, she said, and it is recorded in Assamese, perhaps this meaning will also be different. The page number 21, earlier when I recorded my statement before the magistrate and police, I stated that the place of occurrence was within the premises of our house. That then I did not state.
Please carry on with the Assamese, my brother.
There, in fact, Mr. Chaudhary was here. He can read the Assamese part very nicely. You can read. Here, I'll just read out the Assamese part. Oh, it is. Oh, yes, he can read. Mr. Chaudhary, you can read. He was for the informant. Earlier when I recorded,
আগতে হাকিমৰ ওচৰত আৰু পুলিচৰ ওচৰত ঘটনাস্থলী আমাৰ ঘৰৰ চৌহদৰ ভিতৰত বুলি কৈছিলো।
That it stopped, full stop. That earlier when she said this is the same. She said that the incident had taken place inside the premises.
তেতিয়া নূৰ মহম্মদে মালেকেশ্বৰৰ মূৰত মাৰি ইয়াত সি মাটিত পৰি যোৱা বুলিহে কোৱা নাছিলো।
তেতিয়া নূৰ মহম্মদ কোৱা নাছিলো. But in her 161 statement, I'll say 161 statement is readable. 161 statement, she said, ওচৰত থকা আমাৰ অনুমান ইমানমান বজাত ঘৰৰ চৌহদৰ ওচৰত থকা আমাৰ মাটিত ইদ্ৰিছ আলীয়ে হাল বাই থকা দেখি মোৰ স্বামী আমিৰ আলী আৰু মোৰ পুত্ৰ মালেকাস্তুৰ গৈ ইদ্ৰিছ আলীক কিয় আমাৰ মাটিত হাল বাই আছ বুলি সোধাত আমাৰ ঘৰৰ ওচৰতে থকা so and so had hit us. She said that when her husband and she saw Idris Ali plowing their land, they asked Idris Ali, why are you plowing that land? On being asked, these people came and attacked. Here the difference is,
That is there in the evidence of it.
It is there in the 161 and it is also there in 164. Oh, I forget. 164 of Ali, this lady Rohima Khatun. Rohima Khatun, in her 164, she also said that they were armed with sticks. Meshed, Nizamuddin, Hegdin, so and so, everything she had stated in 164. As well as in 161. What she did not state, what she contradicted is, the incident occurred inside the premises of her house. That part is not there.
What is this difference between the campus and non-campus area? What is this? What is the translation? What is the Assamese version?
Uh, Premises, matlab, it's a courtyard. It's
I
a-
know, I mean, outside they saying campus or something like that.
So hot.
In the other
So
part, in the
what
field, in the paddy field.
And her field and her house are
How far,
contiguous.
how far?
So it is part of the.
It is contiguous.
No, it's
contiguous,
field,
correct.
house, road is there. Far apart. It's somewhere in the evidence, my. You are
In the Assamese version.
Our lordship will see the sketch map then once.
sketch map.
112. A, C and D is in pond and agricultural land. So A, C and D. D is the agricultural land. C is the pond. A is the house. Amir Hassan's house. A, C, D. B indicates Amir Ali's house. This is deceased house. B indicates the place of occurrence. E is the east E quota. F. Honey, quote F. F9. Oh, yes, yes. This is the road where Malakosto's body was lying. So everything was together, field, house, road. And my humble submission, there is no contradiction as far as 3 and 4 are concerned. Contradiction only to the extent that the incident had taken place in the premises of the house. Otherwise, beating part have all been corroborated. It was corroborated on 164. 164 was also seems to have been placed before PW4 because she said that police produced me in the court and got my statement recorded. And then she said, earlier when I recorded my statement before the police, I stated so.
No, E এটা আছে.
Huh?
E এটা আছে. E, Assami.
This is the left.
Place of occurrence is E.
No, her submission is,
Hmm.
the defense counsel submission is,
Hmm.
as PW3 has given different version as regards place of occurrence.
Hmm.
Therefore, she is not the eyewitness.
Now,
That
this
is your
is one of
submission.
her argument.
One of,
Huh. Now PW3.
what is your reply to that?
Yes. PW3, what I can see is
PW4.
PW4.
PW4, PW4.
Huh. PW4, in fact, she said incident took place on a road across the field. So it is field and the road are together, they are contiguous. The road was running across the field, as we can see from the sketch map. Of course, the dispute is regarding plowing on a particular land, where both the parties were claiming their ownership. Now, incident had taken place little away from the field on the road.
No, what she meant by using word sohad, is it only house or it includes field also?
So what will include a larger area? It cannot be simply house.
Campus including pond, field, everything.
Everything has to be. Because in her 164 also, what she said, I'll see. So now what I can deduce from your lordship as well as from her, that there is no contradiction as such, as far as the beating part is concerned. That perhaps lordship is convinced with that. As far as campus or as far as the place of occurrence is concerned, what she said in her 164, so and so entered into our campus, they were armed with sticks. In her 161, she stated, campus niki
Was
161.
within the premises of a house, within the premises. of a house.
Onuman Iman Idris Aliye, কি এইটো ইদ্ৰিছ আলীয়ে হাল বাই থকা দেখি আমাৰ মাটিত
মোহাম্মদ ইদ্ৰিছ আলীয়ে হাল বাই থকা দেখি মোৰ স্বামী আমিৰ আলী আৰু মোৰ পুত্ৰ মালেকশ্বৰক গৈ ইদ্ৰিছ আলীয়ে কিয় আমাৰ মাটিত হাল বাই আছে বুলি সোধাত আমাৰ ঘৰৰ ওচৰত থকা মোহাম্মদ আমিৰ হুছেইন ৰিফিউজ দিলে
Then they attacked. So as far as, and Lordship had seen the sketch map, they were all together. So this is not, it cannot be fatal that she had used the term campus, entered into our campus. They were armed with sticks.
Within the premises.
And in her statement before the trial court, she said the incident took place on a road across the field. Malekastur came along the road across the field. Asked accused address while he was. So road, her place and her house were all together, and she said they entered into the campus. Campus is a larger area. It cannot mean only the house. So as far as 3 and 4 are concerned, in my humble submission, they are the eyewitnesses. Contradiction only to the extent that the incident had occurred.
What was the injury sustained?
Injuries are all sharp cut injuries on so many parts. Yes, sir. Yes, he said sharp cut injuries, temporal region. Amir, it is temporal and parietal. Malekastur, sharp cut injuries on neck. So it corroborates, yes, it corroborates the version given by the eyewitness. They attacked on the neck and the head.
Any citations?
Corroborations by the medical evidence.
So, that boy, the brother, it was only injuries on the leg.
I think so. PW6.
What was the cause of death of that brother?
PW6. Cause of death, here they are saying sharp cut injuries on larynx, neck, major vessels of the neck, chin, cut injuries on mandible region of about so and so in the mandibular bone fracture, sharp cut injuries on upper part of the ear, left ear, abrasion in the hand. So cause of death is asphyxia and hemorrhage as a result of the injury sustained. So major is neck, ear and this part, mandible area and all. And the father is of course head injuries, temporal, parietal, nape of the neck, and yes, temporal, parietal, nape of the neck, nape or whatever, fracture of sagal bone. So coupled with the evidence of 3 and 4 and corroborated by the doctor, I thought that the entire evidence has been contradicted. But by checking 161, I saw that no, entire evidence did not go. Only place of occurrence. Place of occurrence, Lordship had seen from the sketch map that everything was together. Injured witness, I can place a judgment. Injured witness has to be given far more importance than any other. Lordship. Injured witness, I had in fact placed a judgment before Lordship Kalita the other day. I had placed one injured witness. Yes, Lordship, I got the judgment. This is, again, I've taken it from Manupatra actually. This is Supreme Court judgment. But because Manupatra is very easier to search and we get so many decisions of High Court. Somewhere, something I'll get. That is how I search in Manupatra. This is Balu Sudam Khalde and others versus State of Maharashtra. Lordship can see, and I can give your Lordship the SCC area also, the citation. I've sent it, you can take out, yes.
Is it a long judgment?
No, Lordship, I'll just, that is what I'm seeing. There are 66 paragraphs. So Lordship
No,
can.
we will just give us the citation.
A
Just piece of
Lordship, yes.
paper. Just give a citation.
I've given the Manupatra citation and I'll refer the paragraph.
Yeah. What is the SEC citation?
SCC equivalent citation I did not get.
Okay. Just give us the first page or second page.
Lordship. First page.
First page with the.
First page and the relevant paragraph, paragraph 26. Paragraph 26 to idea and the first page. Paragraph 26 will be in which page? I don't know. Paragraph 26.
Yes, what else?
This is what, in fact, injured witness, let us read the judgment. Injured witnesses, both of them are injured. They have stated both to the police, to the magistrate, as well as the trial court, the same statements. Place of occurrence, Lordship can deduce from the incident that they were all together and it had happened.
Jury report is not there. If they are injured.
Injury report, I've tried to find out.
Not there. My lord, I take your
Perhaps there
lordship to
are alleged
judgment part
people, there was a fight, they did not go to the doctor.
They might not have been injured.
Lakhimpur Hospital.
No, no. Page 80 of the judgment.
Okay, I
Page
might not
80 of
have
the
collected. Paragraph 26, Lordship will see this. Very nicely quoted. When the evidence of an injured witness, eyewitness is to be appreciated, the undernoted legal principles enunciated by courts are required to be kept in mind. The presence of an injured eyewitness at a time and place of occurrence cannot be doubted unless there are material contradictions in these repositions. 2, unless it is otherwise established by evidence, it must be believed that an injured witness would not allow the real culprits to escape and falsely implicate the accused. C, the evidence of injured witness has greater evidentiary value, and unless compelling reasons exist, their statements are not to be discarded lightly. The evidence of injured witness cannot be doubted on account of some embellishment in natural conduct or minor contradictions. If there be any exaggeration or immaterial embellishments in the evidence of an injured witness, then such contradictions, exaggerations, or embellishment should be discarded from the evidence of injured, but not the whole evidence. Only that part needs to be
No,
discarded.
here, whether PW4 and PW3 were injured or not.
It seems
Because
they,
Trial court
yes,
has acquitted the accused person under 326,
Page
On the-
45, my lord.
325 on that ground that
Page 80 of the judgment.
injury report, they have not,
So can we consider them as injured witness?
because
what material
they
is
have
there?
been taken
apart
to the
from
hospital is there. PW2 had stated that they were taken, Lordship will see page number 12. My mother and Sheikh Farid then I sent my mother and Sheikh Farid to Lakhimpur Civil Hospital with Sahed Ali for their treatment.
PW2.
PW2 had stated they were sent to the hospital.
PW3 is also.
PW3, Lordship will see.
Last line of the chief.
My elder brother Kudus took me and my mother to Lakhimpur Civil Hospital for treatment. 4 must have also said. And then 4 also said, Sheikh Farid and I went to Lakhimpur Civil Hospital for treatment in a police vehicle. I checked, I did not get. The doctor was also a witness in the charge sheet, but he was not examined.
There was one seizure, my lord, with regard, but all the seizure witnesses are not examined. The seizure, there was no weapon of offense found in the place, my lord. They have found some cover of the factory. There were some witnesses, those were not examined, my lord. No blood stain was seen by anybody at the place of occurrence.
One kukuri is seized.
No, not kukuri, kukuri cover. Kukuri cover.
Kukuri cover.
Cover.
110. Yes, just check up.
Exhibit.
But one wooden sheet of a kukuri, length of which is so and so. And it is
The
wrapped with
witnesses
tape.
are not examined, my lord. There was not even a single blood stain stated by anyone. No blood stain was recovered, my lord. No blood stain body was sent for FSL, no, it was a part of seizure, my lord. And injuries to eyes remain intact. The PW 3 and 4, my lord, there was no injury, there were no eyewitnesses. How can PW 2 be considered who stated that clearly that I have seen this person plowing the land and sitting near the pond? In the cross immediately stated that no, I have not stated all those facts. How can PW 2 be considered as reliable in that case? PW 2 at the last line, he said, then I saw that accused Idris Ali was plowing in the land belonging to accused Amir Hassan, and rest of the accused persons were sitting on the bank of their pond. Immediately in the cross, he said, I did not witness the find. I did not state that. When accused Idris Ali was plowing the land belonging to Amuk, the rest of the accused persons were sitting on the land, bank of the pond. All were brothers. And, my lord, the most important part is that who is benefited, praised down. Malketasur, in one of the deposition I have seen, yes, page 15, my lord. Malketasur was unmarried, father was 65. In the defense has tried to bring in every aspect that you were those two persons who have killed him. And PW, my lord, he was not examined, but PW 5 has stated that there was a fight between one of the brother and Malketasur. He has seen that fight. He has witnessed PW 5. So, my lord, at page 24, the last line, before this incident, Jabur and his elder brother Jalil assaulted Malketasur in the field. Page 24, the last line. So, my lord, I remain stand to my point with this aspects that they were not eyewitnesses. Who is to be benefited is to the creation of doubt. These are the persons that are benefited. One is unmarried, one was 65. The land is being now enjoyed by them. And moreover, my lord, no blood stain, no injury, no deposition. Seizure witnesses are not examined. Who will be benefited, my lord? The benefit will be obviously to the prosecution. Exhibits are not given. Who is benefited? So these all aspects, my lord.
Benefit, so that is not our issue.
my lord,
That's not
that is-
nothing for us to consider.
In fact, as far as
We are-
medical injury reports are concerned, there are stipulations in the case diary that they tried to collect the injury report, but then the doctor was transferred to Dibrugarh Medical College Hospital and it was difficult for them to collect. And 149 lordship is there, 149, the findings are also there by the learned trial judge. Here at page 79. Lordship is not sitting in the second half. And
No, I've got another TP.
yes. But 149 findings are there in the trial judge's statement, judgment at page 79. They were sitting in the bank and they had accomplished their common object. So injury report, of course, are not there. But then the statements are there. They were taken to the hospital. And they have not brought in the defense that we are not injured and all. That is not there in the defense.
That's all.
If Mr. Chaudhary is there.
You want to say something?
I will adopt her, madam. Yes. Okay.
No dispute with the fact that they were at the place of occurrence. They have not nullified that statement. In the
Heard,
cross.
Miss,
SG Burwan.
your name is not here.
Subsequent.
SG,
SG Burwan.
Miss SG Barwa, Senate Counsel for the Appellant. Also heard Miss S. Jahan, additional PP. As well as Mr.
DM Chaudhary.
U. Chaudhary, Senate Counsel for the
PM
response.
Chaudhary.
DM, huh?
DM
The BM Chaudhary,
You
BM
Chaudhary.
Chaudhary, Senate Counsel for the respondent number 2. Hearing concluded, judgment reserved.
Okay.
As Secretary to the Honorable Chief Justice. That was on what basis?
That was
Officiating.
on officiating basis. It was on
10-9.
He was in the feeder post.
Yes, he was in the feeder post. That was as a protocol officer. He was that time holding the post of protocol officer.
Protocol
Yes.
on regular basis.
Yes, our contention, he was on a regular basis. They want to make out a case that no, it was not in substantive capacity. He was holding the post temporarily as an ad hoc appointment. That-
So that is the crux then.
That's the crux, but the fact remains that they didn't challenge my appointment as the protocol.
No, whether they challenge it or not,
Yes,
the issue will be whether he was on a regular basis in that post or not.
or, yes, exactly. If, Lordship is exactly the same point, if this honorable court finds that my appointment as a protocol officer was a substantive appointment, and I was holding the post on a substantive capacity, then I come within the feeder post with zone of consideration, and then I am entitled to be considered and appointed as. Then the second question will come, whether my appointment to the post of secretary to the Honorable Chief Justice was correctly done, or there was any ambiguity, there was any irregularity in my appointment. These two questions, basically, your lordships will have to decide. Just to indicate the learned, yes.
So let us go to the first issue at hand
Yes,
as to whether you were holding the post of protocol officer on regular basis.
yes. Then lordship will kindly come to page 143 of this.
Of your appeal. 143.
143 of the April memo. This is the notice calling for options for the post of protocol officer. It is on dated 2nd September 2016. Now, this says like this: options are hereby invited from the intending senior judicial assistant of this registry for filling up of one vacant post of protocol officer. Kindly mark, my lord, one vacant post of protocol officer in the principal seat of the Guwahati High Court in the pay band of such and such, plus grade pay of such and such, plus other allowances as admissible under the rules. Preference will
Mr.
be,
Mahanta, just one thing.
Right.
Yes. I think you are in agreement also that this is the issue. This is the starting issue. This is the main issue. No, I mean, this is the starting issue. So this is the starting point.
And
Correct. So let us cross this.
yes, learned single judge also held that this is a temporary appointment. That is why the issue is pertinent.
Okay. Anyway, so let us see this. So
Yes. Now kindly see the nature of the advertisement, my lord.
Mm.
That is why I am placing it.
Mm.
It has given everything. It's a vacant post with pay band, grade pay, allowances admissible under the rule. Preference will be given to those senior judicial assistants who have completed 5 years of service. Then, second parallel, the selected candidate for the post of protocol officer will maintain his her seniority in the original cadre, and his her further promotion will be considered on that basis. This is a condition put here. Let us, for the time being, forget it, my lord. I will come to it. But that condition your lordship will note. Willing candidates may submit options mentioning their service profile to the AOJ establishment on or before 7th June. Now, this advertisement contains this particular clause, conditions, second para.
in the form of second para. It will be pertinent at this point to take your lordship to the similar advertisements earlier issued for this post. What was that? Kindly see.
Previous page.
Previous page 141. 141.
Yes.
This is dated 10th of April 2014. Options are hereby invited from intending SAA, now Senior Judicial Assistant of the Guwahati High Court, Guwahati, for filling up of one vacant post of protocol officer in the principal seat of the Guwahati High Court, Guwahati. Options are hereby invited from intending JAS, now Judicial Assistant at the Guwahati High Court, Guwahati, for filling up of one vacant post of Assistant Protocol Officer in the principal seat of Guwahati High Court, Guwahati. The intending candidates may submit their options in the establishment section during the office hours so and so before so and so. The lordship has seen there is no such clause that they will be on appointment, their seniority shall be maintained in the lower cadre.
So there is one, the first question that comes up is whether this protocol officer, is it a promotional post or a deputation?
No, not a
Deputation post,
promotional
what is it?
It is a direct recruitment from in-service.
It was an ex-cadre post.
Huh?
It was an ex-cadre post.
It's an ex-cadre
No,
post.
it was
Was.
an ex-cadre post. Thereafter, the High Court encadred it in class 2C of the service.
When?
It was encadred in.
It was encoded in
1999.
My lord, it was encadred on 8/6/2011 with effect from 25/2/19.
And cadred on
At 8/6/2011,
8/6/11 with effect from
25/2/99. That is the date of.
25
to
to
1999.
99.
That was the date
Retrospective effect.
with retrospective.
1999 as a class 2C,
2C.
that lordship will find at page 140.
as a class 2C post.
Lordship.
Page 140, my
And
lordship.
this post
Page
40
40.
of this
140.
140.
40.
Yes. Just previous page. Now lordship was looking into 141, see 140. Both protocol officer and assistant protocol officer, which restores respect from 25 to 99. Those were encadred.
Okay, now, so this PO post. So what is the entry grade? The entry grade, is the assistant protocol officer, or what is it?
No. This is senior judicial assistant. From senior judicial assistant cadre. Yes, yes, you please. Let the clarification. come from the High Court.
Let us
Yeah.
clarify these small
Yeah, yeah.
issues. here.
My lord, when this post was created in 25/2/1999.
Yes, when was the post created?
It was created on 25/2/1999.
PO and APO both.
Both, my lord.
PO and APO posts.
Both created in 25/2/1999.
Just a minute. Created on 5.
25.
25 to.
Two.
By the government of Assam.
Assam. PO post was, protocol officer was created in the rank of superintendent.
Just a minute. Equivalent to PO, equivalent to
Superintendent, which is now called administrative officer bracketed judicial.
administrative officer, judicial.
And my lord, a assistant protocol officer was created in the rank of equivalent to SA, UDA, now called
Equivalent to
UDA, my lord, at that point of time.
now,
Now, my lord, senior judicial assistant. Yes, senior judicial assistant.
are you sure?
Yes, yeah. Yes, Jay.
Okay, then,
My lord, this post, when it was included in class 2C, there was no feeder cadre for this post.
okay, just a minute. APO, Assistant Protocol Officer is equivalent to Senior Judicial Assistant.
And my lord, when it was included in the rules, my lord, there was no provision made in the rules as to how this post would be filled up. It was and there is no provision therein from the post of protocol officer where the person will go. Even, my lord, an assistant protocol officer cannot go to protocol officer.
Okay, so what do you call this type of post?
These are, my lord, isolated posts in the cadre. Because of the need, because that post is needed for the functioning of the court, protocol officer is required, my lord. So that was created, the cadre was created and the post was.
There is a certain term used for this type of
It's
post.
normally called, my lord, an isolated post, maybe, my lord. I'll just come back. to that.
There is
Ah,
another.
There is another appropriate term, my lord. I'll come
Yeah.
back to you. It's not just coming down. Then what happened, my lord?
You know,
No, my lord, but also, but there is a resolution of the Honorable Service Committee meeting dated 9/2/2000.
I'm coming to that. I'm coming to that.
I'm not on that.
I'm coming to that. I'm coming to that. Then, my lord, the single cadre post, my lord, or if my lord says, no, my lord, there's a
It's not
word. I said.
single, it's not. There is a certain word.
So,
That's
yes,
where it's isolated, you say, right? Correct, but isolated.
Isolate that, but there is a
there's a-
specific word.
Yeah, specific.
I'll
word.
come out with it, my lord. Then what happened, my lord? There was nothing, my lord, how to do it. So, my lord, this post of protocol officer, it's a permanent substantive gazetted post, both. Protocol, assistant protocol officer and protocol officer gazetted post.
Gazetted post.
Gazetted post.
Gazetted post with no RR.
With no RR. There is an RR, we have an RR, but there is no provision for filling up of that post or from that post where person will go, it's not provided.
There is an RR.
We have an RR, my lord. We have a rules of 1967.
How you going to do? What do you mean?
My lord, if my lord can have the Guwahati High Court rules,
Just give me the Guwahati High Court rules. Acha, it's there.
my lord will come to 637. Madam.
Madam,
Lordship. It will get this. My lord has that 637. My lord will come
I
straight
think
to.
this matter we have to go slowly and surely.
Surely, madam. I'll do. that.
Otherwise, because probably you are all going up either one of them. So we have to be careful that we do our job properly here. Yes, so
My lord will come to 664.
664.
I'll take my lord through the rules, but my lord will come to 664.
Okay, 664. What is this chapter?
This is my lord, schedule 1. 664.
Okay, schedule 1.
Schedule 1. Then my lord would see top category of post, title of post, everything. It's in pursuance to rule 11. Gazetted officers class 1. Then my
Yes.
lord, class 1A, class 2, class 2A, class 2AA, 2B, 2C, my lord. My lord has got it. 2C.
Yes.
2C, first post is administrative officer judicial, which is superintendent, my lord. Then court officer, then my lord, protocol officer ex cadre, but this has been subsequently N cadre, my lord. 2 posts. Then my lord, it goes to class 2DD, 2 assistant protocol officer. So, my lord, there is a provision in the rule how you come to the administrative officer. And from administrative officer where you will go, it's provided for. But my lord, there is nothing in the rules as to how the post of protocol officer would be filled up. And an incumbent in that post of protocol officer, say, my lord, what will happen? Where will he go? It's not there. Now, what had happened, my lord? This honorable court, the committee of this honorable court, first, my lord, on 25/7/2014, appointments promotion DPC committee on 25/7/2004 took a decision that from earlier how we are following it that we take options for the post of protocol officer from the senior judicial assistants.
Options to be taken
From senior judicial assistants.
from senior
Judicial assistants.
assistants.
And
Okay,
for the protocol officer, assistant protocol officer, from the junior judicial assistants.
junior judicial assistants.
Lordship.
Just a minute. Okay,
Then, my lord, subsequently, on 9/3/2015, same very committee, my lord,
9-3,
2015, my lord,
yes,
same very committee, by reiterating its decision of 25/7/2014, said they will be appointed. Now the word used is appointed as judicial, as protocol officer,
PO will be appointed.
appointed. But for the purpose of their promotions, their seniority will be maintained in their original cadre.
Okay, okay. But for,
The purpose of their promotions,
for promotion.
they
Okay,
will-
so that is why this thing has
this
come.
thing has come. Now the issue is, my lord,
But for promotion, their seniority.
will be maintained in the cadre of SJ, my lord, that is senior.
No, it'll be SA.
Sa, it was then again became senior judicial assistant.
As senior judicial assistant. Then,
Then that was the condition. That is how, my lord, they were appointed, granted that gazetted status, given all perks, but in the appointment order, this rider was there, that your seniority will be maintained for purpose of promotion in the cadre of SJA. Now, the issue, my lord, is whether they are a member of 2C.
2C.
2C. If, my lord, they are a member of 2C, my lord, then they come within the ambit of the rules 373A for being considered for appointment as the secretary. to
Where
the-
is the 7-3?
7(3)(a), my lord, would find in the rules. My lord would come to page 640, madam. My lord has got it.
Yeah.
The secretary to the Honorable Chief Justice shall be appointed from among the gazetted officers of the High Court Service belonging to class 2AA, class 2B, or class 2C, having a degree in law, considered suitable by the Chief Justice.
Yes.
Now, my lord, my first contention, my senior would, my lord, take it further. My first contention would be, my lord, that there being no method of recruitment provided in the rules, this being an appointment, till that man is there, my lord, he, for all intent and purposes, is an incumbent in class 2C. Because he is given all the pay, perks, everything attached to that.
Which is higher than.
Which is much higher, my lord, much higher. It's equivalent to the next promotional post of SJA, which is Administrative Officer Judicial. Now, my lord, so this is a method of recruitment provided to that post. My lord, in absence of any other provision anywhere, this is the method of recruitment. And that, my lord, for all intent and purposes, my lord, for his permanency. Now, my lord, this man, protocol officer, my lord knows, we all know, he has an honor. It's a unique post, my lord. Both the post of secretary, CJ, and the protocol officer, these are unique posts. These are not desk jobs. He has much other activities to do. That is why, my lord, the committee, in its wisdom, said that you don't have a provision for promotion. The post of CJ, secretary, Honorable Chief Justice, is not a promotional post. It's again an appointment. Selection and appointment. How the selection is made, all the names of the persons in the classes that are mentioned there, 2A, 2B, 2C, all the names along with their records are placed before the Honorable Chief Justice. That's the normal report. The Honorable Chief Justice then makes a selection on his own. Because that post, he requires a man who he considers to be confident, who he can repose confidence upon.
No, that is a different issue.
No, but I'm only on the protocol officer. Now, once he is there as a protocol officer, he will for all intent and purposes be a member of class 2C. If that is accepted, my lord, then he comes within the zone of consideration as secretary, my lord, honorable Chief Justice. And that promotion as, my lord, secretary or protocol officer is nowhere under challenge. In those proceedings, it was never challenged.
His promotion as protocol officer.
Protocol officer was never challenged.
Is it a promotion or?
It's not a promotion, man. I'm coming to that. That appointment as my lord protocol officer was never challenged. Now, before the honorable single judge, if my lord, I take my lord through the judgment, my lord would find a projection was made that this is a promotion. So if it is a promotion, then you have to follow the criteria for promotion, which we normally follow in the High Court. The person zone of consideration, the first people who are there. Now, let's say if there is one post, another 5 people, 6 people who will be called, they should be called. It should be on merit come seniority. Those factors having not taken into account, having not been followed, this is bad. The honorable single judge also, my lord, accepted the fact that this is a promotion and proceeded in the matter. And that's where, my lord, I feel that, subject to what my lords would say, that the error appears. If it was treated as an appointment, my lord, then it would have been a distinct thing. Then it would not have had those, my lord, doubts being created that you have not followed the norms of promotion, how you can do it. Now, what has happened? This post is not filled up on pick and choose basis. The committee had laid down the norms. How it will be filled up? My lord has seen the advertisement.
So, yes.
My lord has seen the advertisement. Options are called for.
Yes.
They submit their options. It comes before the authorities, shortlisted, and then, my lord, an interview is held. A selection is held, headed by an honorable judge of this honorable court. They are marked. Who is found suitable is given appropriate marks. Thereafter, it goes back to the committee, and the committee then approves it. And thereafter, the appointments take place. There is nothing there to show that this was an ad hoc appointment. This was, my lord, for all intent and purpose, a permanent post. By following a process of selection, the person was appointed. So, my lord, for all intent and purpose, that appointment is a substantive appointment. Now, that condition, it can be understood in many ways, my lord.
Yes.
That condition is that this man is working there. Now, he does not have an exit from that post. He's stuck there. Stagnated. He will stagnate there. But this post is equivalent to administrative officer judicial, which he would aspire for if he is in that line. If he continued as a senior judicial assistant, he would aspire for promotion to the post of administrative officer judicial. So this provision was made that in the event of your promotion, because, my lord, if it was a case.
No, again, it boils down to that word I want for one thing. What is that word they use when there is a post? Is it isolated post type? Where there is no further avenues for promotion.
Stagnation.
No. There is a, you see, there was, even in the state of Mizoram, there was a post in the health department, malaria officer was there. And once you got promoted to that post, then there was end of, you couldn't go further as to director line and all that stuff. There's a certain word used for those.
Certain expression to describe that.
Yeah, there's that post where there's no further avenues for promotion or going. You know, it's
isolated post.
Super time something.
No, it's an isolated post, something to that isolated post.
But there is a word. I'll get back to you.
So my thought,
Lordship.
just can this post of PO be said to be that type of post?
It's that type of post.
So if it is that type of post, and if there is no rules providing its future
Lordship.
course of action, then won't he be stuck there?
That's why, my lord, this connection. That if you get promotions here, that would be, my lord, you would be getting that benefit here.
Is it something like co-terminus?
No,
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 no, no, no. They are proper government servants. They get pension, everything.
But once he attains that position,
There-
no further.
No further.
I'll get back, my
You
lord.
see, there's a line, he goes this way. He cannot come back. He doesn't, there's no provision, there's no rules.
So
for
he has
coming
to
back.
end there. His
Yes.
service career will end there.
And there. So there is a certain word. you know.
It's there, my lord, it's not coming out. I'll give it to you, lordship. But it means an isolated post.
Yes, it means as isolated.
Isolated.
It means that.
Now, my lord would see, the post of protocol officer in class 2C does not have an exit. I'm using the word exit that he cannot be promoted to any post from there. So that's the end. Now, the only option given here is that he can be selected under 7(3)(a) to the post of secretary. And that's, my lord,
Under what rule?
under that rule 7(3)(a).
You see, in 7.
640.
In 7(3).
7, my lord will have 7.
Ah.
At 1639, 639, it's gazetted officers. My lord has got it. 7 gazetted officers.
Yes,
My lord would come back to 3A at 640.
yeah.
The secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officers. My lord will
Okay,
use
okay, class 2.
or 2C.
Okay. Okay.
So, my lord, if he
So
is
he comes under that.
that, and therein how it is done, there is no selection, there is no options called, nothing, my lord. The names, the registry puts up before the Honorable CJ with, my lord, his service particular. And the CJ has the discretion to pick up, choose any one of them. Now, what happened in this case, my lord? Because of a note of the registry, which was put up, which said that that condition is there. So initially, my lord, he was selected. There is a note wherein the Honorable Chief Justice has written that Niroj Sharma is selected. There is a note. There's written that in that note of the, as my lord knows how the High Court CJ's signature is there, he wrote there. And accordingly, because of this condition, he was appointed on officiating basis. I have a reason for telling this. He was appointed on officiating basis initially as secretary to the Honorable CJ with this condition again, that his promotions and all will be maintained in the cadre of SJA. This went on for some time, around 2 years he served. Then the registry put up a note as to whether he is continuing, whether it's fit in the fitness of the things. This post a person on ad hoc basis should be continued. Then the Honorable Chief Justice, these are Honorable Chief Justice, gave a detailed note as to why he thought that this person should be there on a permanent basis. That is how, after that note, my lord, he was regularized. Now, what happened to the post of protocol officer? If we go by the decision of the Honorable Single Judge and the contention which the petitioner seek to advance, my lord, once he moved out, somebody else would be there in the same manner, my lord. It did not happen, my lord. Till the time Niroj Sharma was on officiating basis, the secretary to the Honorable CJ, this post was filled up on officiating basis, protocol officer. Once he was regularized there, then only a person was put in there on regular basis. Regular basis means in the manner, my lord, Niroj Sharma was initially appointed. So that officiating thing in between, after he was the officiating, my lord, secretary to CJ, shows that, my lord, a lien also existed against of Niroj Sharma in the post of protocol officer. If that has existed, my lord, that appointment is a substantive. This is, my lord, broadly the manner in which the matter occasioned. If my lord goes to the judgment, my lord would find their contention from paragraph, give me my notes. From paragraph 8 onwards, my lord, it's promotion.
It's a promotion.
It's a promotion. Which
To the post of PO.
PO and also to the post of my lord, standalone posts. It comes nearby, but there is another word.
That's not the word.
No, that's not the word. And my lord, in para 9, their submission is clearly recorded that we are not assailing the promotion to the post of PO. And the regularization in para 10, they say, by regularizing him that post, you are shutting us out for our promotion revenue there. Whereas, my lord, there is no promotion revenue for the post of protocol
There's
officer.
no promotion level to the post of PO
It's not there.
because options were called.
Options were called. And who had not
How many,
opted?
how many times has options been called for?
My lord, it has been called for from 2014 regularly. Whenever there is a vacancy, it's been called for. And people, because my lord,
And once they join the post, then where do they go from there?
my lord, either they are at one instance is there, Ranadev Das, my lord, there is an instance there. He subsequently got promoted as AOJ, Administrative Officer Judicial, and then he was given that post seniority from the
which
date
post?
from my lord, he was holding the post of protocol officer, but he was originally a senior judicial assistant.
But then he got promoted from which post?
His case, my lord, was considered for promotion to AOJ because of that assistant. No. He was considered as, my lord, Administrative Officer Judicial.
Because administrative officer judicial is equivalent to PO.
I'm coming to that. Then, my lord, he was given there, he was sent there with seniority counted from the date he was appointed as protocol officer. The one instance I could get. The others, my lord, they left that post. They did not stay there. They wanted to go back. They went back. So they have a lien there. They had a lien there. So they went back. But this man, he was picked up. He had nothing, my lord. He had no role. He was picked. He was selected on examination of records, found to be satisfactory by a Chief Justice, who, my lord, gave him an officiating appointment as then, my lord, subsequent Chief Justices, he worked. Then, my lord, finally on 24/8.
No, one thing, what this senior judicial assistant, what is
Lordship.
the normal promotional post?
It would be, my lord, next promotional AOJ, Administrative Officer Judicial. Equivalent.
Either way.
And then they'll go to assistant registrar. So, my lord, this is the manner in which this promotion took place. My lord, just to advance on that point, give me that order. If my lord, I'll go on that in details, but just to, my lord,
No, if AOJ and PO are equivalent. Now, if they're equivalent, and if the promotional post of SJ is AOJ, then
He comes up-
then the appointment of this person, the appellant, as PO. What it can be said to be what? It can be impliedly to be a promotion or
No, it's not.
appointment,
It's an
direct
appointment,
appointment.
because it's an appointment within that service, my lord. Who is selected within that, sir? Because in service, my lord has found.
What happens
Lordship,
in service jurisprudence
lordship,
when there is a post and no service rules are there for that post
lordship,
or recruitment rules,
lordship.
and a person gets appointed to that post, then what
Lordship.
happens?
Then, my lord, if the requirement is that there can be a service rule, there can be also an
No,
executive
there
instruction.
can be the different issue.
Lordship.
If there is no service rule, then what do you call that type
Then-
of appointment?
My lord, that appointment, then there would be an executive instruction. Otherwise, my lord, how can the person be appointed to that post? There has to be an executive instruction, something written that this post will be filled up in this manner. Here, there is a committee's decision approved by the CJ, which says that it will be filled up by inviting options. Now, my lord, if it was an officiating appointment, temporary ad hoc, my lord, I'll use the word UDA. He was a UDA. He was appointed as, my lord, the post to the, as protocol officer. He would have been holding the charge of that post, my lord, officiating. He would be officiating against that basis. There would not be a regular appointment with all the perks. My lord. And my lord would say, he becomes a gazetted officer. By coming into
So no
crucible.
one had applied for it besides
There,
him?
no. There were around nine people who had applied.
His colleagues also
Whoever opted, we call them for the interview.
for the PO.
Then the honorable single judge along with the board considered their cases. And then my lord Markey, who was
And
found.
that has not been put to challenge.
No. Not put to challenge. That my lord would find the submissions. My lord would have the judgment, my lord, which is judgment is dated 5/1/23. My lord is holding that pair. I'll just give the number. No, judgment latest from the one. Or start 160.
160.
60.
Yes.
My lord would have 160, starts at 160, order, 162,
Yes.
para 8. Referring to the rules, Sri Patwari Learned Counsel for the petitioner has submitted that from the cadre of SJ, one is normally promoted to the post of Administrative Officer Judicial, in which cadre all the petitioners as well as the interveners are placed. While the cadre of Administrative Officer Judicial is a feeder cadre for the post of HCA, there is another stream for such consideration. An incumbent who is an SJ can be promoted to the rank of court officer and protocol officer, and both the aforesaid posts are also feeder posts to the rank of secretary to the HC. It's never a promotional post.
So from where does he get the word?
That's my lord, their contention. My lord would have para 9. Para 9, my lord.
Yes.
The petitioners contend that as on principle, they are not aggrieved by the order dated 25/11/2016 as options were called for from other SJs at that time. That's my appointment as PO, that his appointment as PO, my lord. The grievance arose by the subsequent action of issuing an order dated 10/9/2018 when the respondent number 5, who was temporarily holding the post of protocol officer, was appointed as secretary to the HCJ on officiating basis. Now, my lord proceeds further. Para 10. Shri so-and-so for the petitioner submit that appointment to the post of secretary to the HCJ is a promotional post and cannot be made by way of regularizing an official. That selection of the Niroj Sharma, my lord, as the secretary first, and the regularization, these are, my lord, one, and it's a one process, same process one. Maybe the Chief Justice gave him some time and then came to a final conclusion, okay, this man is okay, and which is there in the note. Now the conclusions, my lord would find from my submissions, my lord, para 16 and 17. And conclusions, my lord, para 29 on this.
Your submissions are at?
Para 16, 17, my lord, first. I'll take my lord through that. Para 16 at page 166, internal page 20 of it.
Yes.
Per contra, so-and-so, learned senior counsel, so-and-so submits that there is no illegality or irregularity in the impugn orders dated so-and-so and so-and-so. Drawing the attention of the court to the prayer made in the first writ petition, it is submitted that the order dated 10/9/2018 by which the respondent number 5 was made the secretary to so and so on officiating basis, which was under challenge along with another order pertaining to another incumbent who was appointed as protocol officer. The said incumbent has however left the said post and the only challenge remains with the order dated so and so. The learned senior counsel submits that the appointment of the respondent number 5 as protocol officer is however not under challenge. According to the so and so, the said order is a substantive appointment. The learned counsel submits that protocol officer being one of the posts in the feeder cadre, he uses the word promotion to the rank of secretary so and so. There is no illegality in the order dated so and so. As regards the submission of the petitioners that there was a preconceived notion to give the benefit of substantive appointment to respondent number 5. Options were invited from so and so to fill up one vacant post so and so. Now the learned submits that notice dated was issued only to maintain transparency. However, could not elaborate on the effect of the rider accompanying the order on officiating dated 10. That means that seniority will be maintained here, which I said what I said before your lordship. The learned senior counsel so and so that the rules being silent on filling up of the post of protocol officer, which however is to be regarded as a feeder cadre for the post of so and so, coupled with the fact that powers of relaxation has been conferred on the orders impugned are not to be interfered with. As referred to 229 of the Constitution, which gives absolute power to the HA to make appointments. A reference has also been made to section 63A, as per which the HA has a power to relax the qualification eligibility in case of any appointment. He accordingly submits that the petitions are to be dismissed. Now, the conclusion, my lord, would.
No, what about that portion that the seniority should be counted in the SJ, you were saying?
Lordship, that my lord would find in the order itself.
Yes, that was there.
That,
So why was it there according to you?
my lord, it was there because this post does not have an exit, my lord.
Does not have an exit.
There is no promotional avenue to that post.
But just now you said that there was.
No, that is a direct recruitment, my lord. That is not a promotion.
No.
SJ, my lord, secretary to the
No, you see, when he is the PO,
lordship.
that has an exit according to you. Since it is in the schedule as a class 2C.
My lord, class
officer.
2C administrative officer specifically there are provisions, but
Okay.
there is no provision for PO, my lord.
And then,
Then, my lord, there is no other way. If he is there, he'll be there, my lord.
correct, then,
Lord, can I just come in for one point? Lordship wants to know whether this post of PO is a promotional post or is a selection post or is a appointment.
it is a
And
feeder
what-
post, whether it is a
And
feeder post.
why in that order of appointment of the appellant, it is stated that he will retain his seniority as SJ. And it is also being said by both the appellants, my lord, that we have not challenged the order. Can I just come in for 5 minutes, my lord? I want to clarify this position. Because my learned friend, I think he has accessed the record, he knows it. Now, what had happened, my lord? We have, with the permission
Is
of,
there any problem with him?
no, I'm just explaining. I think he's not answering the question I would like to answer.
I'm answering, come back to you. I'm coming to you.
He's not answering. That's why I
That's
stood up.
his perception.
For last half an hour, I'm also
That
sitting
is
here.
his
No,
perception.
no, just let him answer. Let him. Since he's on his legs.
Lordship. My lord, the wording used is in the appointment, Sri Nirot Sharma will maintain his seniority in his original cadre, that is senior judicial assistant, and his further promotion will be considered on that basis.
Where are you reading?
My lord, I am reading at page 144.
Yes.
My lord has seen it. My lord would read that, I'll read that order, my lord, 25/11/2016.
Yes.
In exercise of powers conferred under Article 229 of the Constitution, read with Rule 6 of the so and so, the Honorable Chief Justice has been pleased to appoint Nirot Sharma, Senior Judicial Assistant, temporarily until further orders as Protocol Officer in the principal seat in the pay band so and so with grade pay so and so per month, plus other allowances as admissible under rules with effect from the date of his joining, White Diganta Goswami, Protocol Officer, released from High Court service. Sri Nirot Sharma will maintain his seniority in his original cadre, that is Senior Judicial Assistant, and his further promotion will be considered on that basis. My lord, this line is now being sought to be given the primacy. Whereas mode of appointment is what is to be looked into. The mode of appointment is, there is a mode of appointment that is inviting options, then making a selection, and then appointing.
No, correct. You see, but one thing,
Lordship.
supposing you are promoted to a post,
Lordship.
can't a seniority be maintained in that post?
Yes, it can. Okay.
Another thing, how many posts of PO are there?
Malad, there are now 2 posts of field. One post of field, protocol officer. Single post cadre. Single cadre. From what I am trying to impress upon your lordship is that the rules does not provide a method of recruitment. So this mode which has been given by the committee is the method of recruitment. And you have to, well, it's not that I pick up somebody and put him there. No, there is a mode. People are in, nominations are called for, and then the selection is made, and then it's appointed.
Or is it because it is a post, isolated post, like you said, without there being any rules for entry or exit? There to the set post that a way out has been made so that the substantive post will continue to remain in SJ.
That's it, Madam. So that tomorrow he gets his normal promotion as AOJ. My lord, then he comes for assistant registrar. He's not deprived. Because, my lord, this post has an enormous responsibility. He cannot sit in one place. He'll have to be on the move always.
No, but what I'm saying just now was against you, against your thing.
I am saying, my lord, that is in my favor because why I am saying that is in my favor? Because, my lord, if I am promoted tomorrow, there is an example that I am giving the thing from the date of my this promotion. That did not occasion thereafter, but there is an example in record. That is why I am saying that is in, that's the high court.
Who was that person who was
Ranadev,
promoted?
Ranadev, my lord, Das. I'll just give it.
Ranadev?
I could trust to know, the secretary. No, second. You are born. I'm just giving it, my lord. So, my lord, if my lord continues with the judgment, my lord, if I may just have my lord's attention from para 29 onwards. 170. My lord,
Para 29.
29, page 170.
Yes.
To appreciate the issue, it would be appropriate to refer to the concerned rule governing the appointment of secretary to so and so. Rule 7.3 of the rules, the relevant extract is quoted here in below. After quoting, madam, para 30. Next page, madam. An analysis of the rules makes it apparent that the appointment to the post of secretary so and so can be made on fulfillment of the following ingredients. From gazetted officer of High Court service. I'll show what the High Court service is also. Such gazetted officer should belong to 2AA, 2B, or 2C. The said officer should have a degree in law. The said officer should be considered suitable by the HA. Now, my lord would see. The first three ingredients are objective and nature, and only the fourth ingredient, namely suitability, the element of subjective satisfaction, would come in. There is also no dispute in the bar that the post of protocol officer belongs to 2C. The aforesaid rules are also to be read with 63A, which gives the discretion to the Chief Justice to relax the qualification for appointment. Rule 63A is quoted here in below. Then my lord would see the Chief Justice shall have the powers to relax age or qualification for appointment to the service of the High Court in appropriate case according to his discretion. Because this man did not have the qualification of degree in law.
Did have the qualification of?
Degree in law, which is one of the qualifications prescribed under 7.3A, which was subsequently, my lord, relaxed by the Honorable Chief.
Can it be relaxed?
It can be, but it's his discretion. Because why I'm saying so, my lord will not.
Can qualifications be relaxed?
The provision has been given, and it can be relaxed in a given case by exercising the reasons. My lord,
Or qualification.
all qualifications, both are 63A, age or qualification, both. But my lord, it cannot be in A. There has to be some reason. My lord, the reason my lord would find at page 172, my lord.
Yes.
My lord would see, this is the note by which it was, my lord, directed to be regularized. Considering the consistently good work done by so-and-so, while attached with various Chief Justices depicted from his ACRs, the efficiency, integrity, punctuality, dedication towards duty, without taking break, knowledge of computer application, thoroughness in performance of all tasks, searching judgment, preparing so-and-so, interaction with officers within the institution of other institution, confidentiality maintained by him, his good and differential behavior with registers, as observed by my during his attachment as secretary so-and-so. Sri Sharma has attended office every single day of my tenure as Chief Justice of Guwahati High Court from 9:30 AM or earlier if required till late night. The earlier precedents of Sri Shailendra Chaudhary, absolute discretion vested with the Chief Justice to appoint suitable person to hold the post of Secretary to the Chief Justice. Power vested with the Chief Justice under Article 229 of the Constitution in this regard. Then, my lord, law laid down by the Supreme Court, the fact that Mr. Sharma has been serving on temporary and officiating basis as secretary to so-and-so for the last over 2 years, and in case of such sensitive post, adequacy is not good for the managing and administrating the Secretariat of the Chief Justice. I hereby, by virtue of power vested under Article 229 of the Constitution of India, read with Article Rule 63A of the Guwahati High Court rules, exercise my discretion and relax the qualification for appointment to the post of secretary to so-and-so and regularize the appointment of so-and-so as secretary to the Chief Justice of Guwahati High Court. Now, my lord, see how the Honorable Single Judge has dealt with this in para 33. The aforesaid consideration in the court opinion of this court, while exercising the powers under Article Rule 63A of the rules, cannot be termed into adequacy. Adequate. Adequacy cannot be gone into. It could have been said that these are perverse. Other than merely stating the earlier precedents of Shailendra Chaudhary, there is absolutely no discussion regarding relaxation of the mandatory requirement of incumbent to have an LLB degree. At this stage, the original records produced reveal that Shailendra Chaudhary, the earlier incumbent, was a Class 2B officer, stenographer trained, who was well versed with the stenography and typing, and this aspect played a very important role in his appointment as secretary to the HGJ. As per rules, a post of so-and-so is a feeder post for the secretary to so-and-so. In contradiction, The respondent number 5 does not possess any such qualification, and therefore the case of so and so could not have been cited as a precedent. Now, my lord, this post, there is no requirement that I should know stenographer or title. There is absolutely no doubt in the mind of the court that relaxation power have been vested upon this so and so for relaxing the age or qualification of an incumbent. But whether such discretion can be exercised to do away with an essential qualification is a debatable issue. However, assuming that even a requirement which is mandatory in nature can be relaxed, there should be adequate discussion to show that there was application of mind to do away such requirement. A perusal of the file, noting, however, does not show any such application. As observed above, the case of Sailendra Chaudhary is not similar. While Sailendra Chaudhary also did not have a law degree. That was relaxed. But he was a stenographer.
Did not have law.
He did not have law. So that's why the reference was made that this we have a precedent, we can relax it. But the question is, my lord, that a secretary to the Honorable CJ is not like any other post in the registry. It's a unique post. Both protocol officer and secretary CJ, these posts are unique, my lord. The requirements are completely different. It's not, my lord, like a SA or a JA or administrative officer. The duties are enormous. And with regard to CJ, one condition, my lord,
That part is not in doubt because they have got to look after the household of the CJ.
everything, my lord. The complete work of the CJ and the person's confidentiality is the most important thing. In addition to his expertise of being a very active man. Then my lord would see. Now the protocol officer thing. Oh, I've got the minus. 34, page 174. The court is also of the opinion that the powers vested by Rule 63A, which is discretionary in nature, has to be exercised in a reasonable manner and for a situation of necessity. There is no dearth of eligible candidates in the feeder post. Cadre having the requisite mandatory qualification to be considered for the post of secretary to so and so. When there are a number of eligible candidates, there was no occasion at all to recourse to the relaxation power under 63A to give a benefit to the respondent number 5, who is otherwise not qualified to be appointed as a secretary to the SJ. My lord, all qualified persons in that cadres were placed before the Honorable Secretary. This is not a selection post. There is no question of seniority of merit being applied or seniority being applied. It is the discretion of the Chief Justice on perusal of the materials available on record to select a person to be his secretary. This is a unique feature of that post. And this is incomparable with any other post in the registry. Neither the duties, responsibilities, status attached. Now, my lord would have para 36. Another important factor which intrigues this court is that the initial appointment of the respondent number 5 as the secretary to HES, 36, page 175. Another important factor which intrigues this court is that the initial appointment of the respondent number 5 as secretary to HAG on officiating basis by order dated so and so is itself clouded. In this connection, argument was advanced on behalf of the High Court that since the respondent number 5 was in the feeder cadre protocol officer, there was no illegality in appointing him as secretary to the HCJ on officiating basis. The argument is not sustainable in view of the settled law that even for appointment on in-charge basis or officiating basis, the qualifications required cannot be done away with, and the procedure laid down in the rules has to be substantially followed. There is no procedure laid down. An argument was sought to be advanced by so and so for the High Court that the appointment order of so and so the protocol officer was substantive in nature. This argument, however, is difficult to be accepted in view of the rider attached to the order dated so and so that the respondent number 5 would maintain his seniority in the original cadre of so and so. If the promotion as protocol officer was made on substantive basis, the question of attaching such a rider to the promotion order dated would not have arisen. Now, my lord, the other part that there was a regular selections, options were called, people were given opportunity to apply. These were all ignored. My honorable single judge got stuck to that point wherein, my lord, that clause was there. And that clause, my lord, was because of the committee's recommendation. And the committee never, my lord, thereafter had an occasion to go back and revisit that. And this is not a promotional post. Now, my lord would have. Para 39. The significance of the rider is that arrangements were absolutely temporary, where no right whatsoever was conferred upon the respondent number 5, either to continue as protocol officer or be considered for promotion to the rank of secretary to the HCJ. It was never my submission, my lord, that this is a promotion. My lord, para 39. The significance of the rider means that the seniority, is that the arrangements were absolutely temporary, where no right whatsoever was conferred upon the respondent number 5, either to continue as protocol officer or be considered for promotion to the rank of secretary to so and so. Then, my lord,
if you say that this has not been stated by you at all.
no. What I stated before this before the honorable single judge was that the manner and method which has been prescribed by the committee is the method of recruitment to the post of protocol officer. And that is a substantive appointment, because moment he becomes a protocol officer, he becomes 2C. And till he is in 2C, all, my lord, benefits, perks, everything will be available to him. If he is in 2C, he will come within that zone to be placed before the honorable chief justice. There is no guarantee that he will be selected, but he will be placed. His name also will be placed before the honorable chief justice if the post of secretary to the chief justice is being considered to be filled up. That was my argument. Now, my lord would have page 177, the second paragraph.
Yes.
However, in the instant case, none of the preconditions are seen to be fulfilled. The entry of the respondent number 5 to the post of secretary to so and so on officiating basis was not preceded by any discernible selection process. The incumbent was not in the feeder cadre in his substantive posting, and he did not have the requisite qualification to hold the post on regular basis. So, my lord, there is no selection as such contemplated for the post of secretary to the honorable chief justice. Till date, there was no selection. But there is a consideration made by the honorable chief justice on the basis of the materials placed of all the incumbents who are there in those 3 cadres. Now, my lord would see what the honorable single judge finally said. In view of the above, this court is of the considered opinion that the impugn orders dated 10/9/2018, that is the first appointment as CJ, the secretary to CJ, and 24/8/2020, that's a regularization, by which the respondent number 5 was first made the secretary to so and so on officiating basis and subsequently regularized as such, are unsustainable in law and accordingly set aside. The respondent number 5 is therefore required to be reverted back to the post of protocol officer, if the High Court so desires, or to his substantive post of senior judicial assistant. Now, the reversion to the post of protocol officer itself shows, Malad, that I have a connection there. Substantive connection.
But it doesn't say that that will be a substantive post. It says that.
Malad, he says revert. I'm interpreting that, Malad. If I am to be reverted.
But then you have not read the entire sentence.
I'm coming to that, Malad. The honorable single judge said you can revert him to the post of protocol officer or to his substantive post of junior judicial assistant. What I am trying to say is, my lord, that on my appointment as protocol officer, that was the substantive appointment. I'll show from the records, immediately thereafter, when the post of protocol officer was filled up, which was put to challenge before this honorable court by somebody else, Vidul Vikas Goswami was filled up, it was filled up on officiating basis. Why? Because I was not there on regular basis as Honorable Chief Justice Secretary. That shows the, my lord, application of.
Come again, okay.
My lord, once I was I am, one Mr. Sharma was appointed as the CJ, secretary to the CJ on 10/9/2018 on officiating basis. So he had to move to the post of honorable secretary to the CJ. Protocol officer post cannot be kept vacant. There was another round of selection. But this round of selection, the incumbent was said that it will be filled up on officiating basis only. Why? Because by the regularization of the Niroj Sharma as the secretary to Honorable Chief Justice had not official. So the incumbent who came in next month came in the capacity of an officiating member. That shows everything may not be written in a rule, madam. But these are instances from which my lord can draw an inference. Or if the argument of the honorable single judge or of the petitioners are adopted,
Yes.
I'll show that, my lord, from the records also. So, my lord, that shows the application of mind by the registry, my lord. That this is the way we construe this. It may not have been written much better. It would have been better if it was written. But, my lord, that shows the mind application of mind. And the initial recruitment of Niroj Sharma to the post of CJ, the CJ may have felt that let me have a look at it, how he is so official. Thereafter, he was satisfied. He gave a note that this is the grounds which I found, and that grounds, my lord, will relate it to the nature of the work, that duty that is attached to that person. Because, my lord, the reasons have to be germane to the issue which is there, my lord, which is the duties which the man is doing. It's not rocket science, my lord. He cannot be, my lord, said that this man, the honorable CJ is not required to So, my lord, this is the basic glimpse, my lord, of the whole issue.
We'll just rise for 2 minutes.
Lots. Which may be relevant for considering the dispute, my lord. Starts at 6:37.
6:37. The rules.
Rules, my lord.
Yes.
My lord would have, it starts, then my lord, the definitions, my lord will come to rule 3 at 6:38.
Definition, rule.
No, my lord. Part 2, 6:38, rule 3, my lord. Page
Yeah.
6:38.
Yeah. Yes.
Classification. The services of the High Court shall consist of both the gazetted and non-gazetted posts and shall be classified as follows. So my lord would find 314, the High Court ministerial service is class 2C, my lord.
Yes.
4, my lord. Each category of the service means, my lord, those in 3, 1 to 5, my lord, which includes class 2C. Each category of service consists of so many and such posts as are set out in Schedule 1. Today, my lord, we have 2 protocol officers. There are 2 protocol officers today, my lord, as on date. Then, my lord, would have 7. So, class 2C is a service, my lord. Within that service, there are cadres of administrative officer, stamp reporter, court officer, protocol officer.
Yes. Where are we?
My lord,
7.
rule 7, my lord.
Ah.
Gazetted officers.
Yes.
My lord may have the next page 3A, my lord.
Yes.
Lordship. The secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officer of the High Court service. These words are important because class 2C, a person who figures in any one of the cadres of the class 2C service,
Last 2 CS.
my lord, it's at page 665.
Yeah.
Would be eligible to have his case also considered for the post of the secretary to the Honorable Chief Justice. So the words here, my lord, is who is there in High Court service in that particular services in any one of the cadres there. The secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officers of the High Court service belonging to class 2AA service, class 2B service, or class 2C service. Having a degree in law, now, my lord, considered suitable by the Chief Justice. Here, my lord, there is no parameters given that each consideration should be in this manner. Why I'm saying, my lord, say a promotion from JAR to SAR, there is a consideration given that it will be on the basis of merit cum seniority. ACRs would be considered. Then, my lord, the merit list would be prepared and thereafter given. Here, my lord, for this particular post, there is no such requirement. It's general. It's up to the discretion of the Chief Justice, which flows from, my lord, Article 229 of the Constitution. The only requirement is because of the nature of the post. Confusion is being made that this post is being equated with the other general posts. That is where the, my lord, whole confusion arises. This is a distinct post. Here the persons who is, my lord, whose secretary is being considered, is being chosen, his call is the final call. Then, my lord, would have Rule 11, my lord, page 648. I told my lord that there is services and class 2 is a service, 2C is a service. That will be amended from here.
640?
648, 11, rule 11. The cadres of the different classes of the service in the court, including the number and character of the post and the scale of attached to them, shall be as those set out in Schedule 1. So 2C is a service and these are the cadres there. Now, my lord, would have 63 at page 662, madam. Residuary powers. Nothing in this rule shall be deemed to affect the power of the Chief Justice to make such orders from time to time as he may deem fit in regard to all matters incidental or ancillary to these rules not specifically provided for hearing, or in regard to matters as have not been specifically provided for. Provided that if then it has to go to the Chief Justice. 63A is important. The Chief Justice shall have powers to relax age or qualification for appointment to the service of the High Court in appropriate cases according to his discretion. My lord, I admit one factor, that any person exercising a discretion cannot exercise it in any manner. There has to be reasons. And if the reasons are germane to the nature of the job attached to that post, my lord, then the question of adequacy cannot be gone into. It's his discretion. If it is not perverse, then, my lord, the question of adequacy in my humble submission will not come in. So, my lord, in this view of the matter, the appointment of Nirut Sharma after selection, which was preceded by invitation of nominations, or, my lord, expression of interest, the selection held and his appointment as the protocol officer with the scale pay status attached to that is a substantive appointment. Until he is there in that class 2C service, all benefits, perks, including the consideration under 3A, 7(3)(a) will be available. Now that condition that he seniority and my lord, his promotional avenues would be maintained in the cadre of senior judicial assistant has to be understood in the context, my lord, that this post does not have any promotional avenue. This is a selection post. It has only thing that it says that the appointments because of the committee's recommendation will be from the cadre of senior judicial assistant. That's the cadre from which, my lord, people's nominations can be taken. But once you come to this cadre, until you continue there, my lord, he will be for all intent and purposes a member of, my lord, class 2C. And being a member of class 2C, my lord, any perks, anything, any consideration will apply to. I'm sure, my lord, my senior would place the judgments of substantive appointment. I'm not troubling your lordship with that. I'm leaving it to myself. But in short, my lord, if my lord sees the sequence of events and how the High Court has proceeded in the matter, my lord would find that this is, it cannot be said to be other than a substantive appointment. Otherwise, my lord, if a person is put there on ad hoc basis, that post is permanent.
How many has he superseded?
He might have superseded around 40, 44. 40, huh? Come.
He's
44.
serial 45.
45. So 44 people were there. Nobody opted other than around 8 or 9 people. My lord will also have to factor in that.
No, my lord, plus AOJs.
45,
45, he is in the SJA. Then above that, there is AOJ. Those have also been superseded.
My lord, a question of supersession will not come here, my lord, because options were given. And that's why in paragraph 9, they say, we have no grievance with regard to the promotion of appointee. There's a promotion of so and so to that because options were called for. My lord, if I'm given, my lord will take an example. My lord. In the service, there are promotional posts and there are also limited competitive departmental examinations. In services, my lord would find that a post A to B, there is an access given by way of seniority cum merit. There is another access given by way of, my lord, competitive departmental examination. You appear in an examination, you clear it, you might be, my lord, it might require that you might have 4 or 5 years of service to appear in that examination. You appear in that examination, you clear that examination, you will jump. There is a selection process. If there was no selection process, it would have been a different question altogether. There is a defined selection process, a body headed by a judge of this honorable court. Thereafter, it goes to the committee, and then, my lord, the honorable Chief Justice approves as is the norm, and the appointments are.
Okay, so the promotion, the PO post, that has not been challenged.
Appointment to the post of PO has not been challenged.
Has not been challenged.
No.
So that need not. We not dwell on it.
Dwell on it.
Now
One.
what about the from PO to the
So,
next
my lord,
post?
he is there in class 2C.
Is there any zone of consideration?
Yes, that is 3A, my lord.
No, zone of consideration. How many persons can be
That's
considered?
the beauty of this, my lord. That's the differentiation here. My lord will have 3A again. I'm troubling your lordship with 7(3)(a) at 640, my lord.
640.
Lordship. 640, 3A, my lord. The secretary to the honorable Chief Justice, my lord, you will see the words, shall be appointed from among the gazetted officers of the High Court service belonging to class 2AA, 2B, or 2C, having a degree in law considered suitable by the Chief Justice. So any, my lord, will only have clause page 664, my lord, for a second. 664. My lord has got it.
Yes.
Class 2AA consists of librarian come research officer and senior private secretary. My lord has got it. Then my lord, class 2B consists of private secretaries, grade 1 stenographer attached to the Honorable Chief Justice, private secretaries, grade 1 stenographers attached to the Honorable Judges, other grade 1 stenographers. Then 2C is, my lord, administrative officer, judicial, stamp reporter, court officer, protocol officer, ex-cadre 2, assistant librarian, senior system officer. The incumbents in each of the service and the cadres in therein are considered. Complete particulars is placed before the Honorable Chief Justice. And thereafter, the Chief Justice narrows down to a single person. It's his discretion. Because that words here is considered suitable by the Chief Justice. There is no selection process there. It's a consideration of the materials available on record and the person whom he feels that this man is suitable for me for this particular job. Because the post is unique, madam. It's his satisfaction because, my lord, he cannot have a person who would be a headache for him. But that's the nature of job that is attached to it, madam. So, my lord, the consideration which, my lord, the Honorable Single Judge also made was by equating these two posts with the general nature of the other posts. It did not, my lord, the Honorable Single Judge, in my humble submission, and also the petitioners, in their, my lord, submission, did not, my lord, appreciate the fact that these two posts are unique to itself. This is my humble submission, subject to my lord. The normal, otherwise, my lord, principles of merit cum seniority, merit, all those zone, because they say, my lord, there is a notification, we have a notification. If it is a promotion, we have a specific notification that the zone of consideration, one post would be 4 people. ACS would be considered.
So the basic issue of putting his seniority with the SJ
Lordship
was due to the committee resolution.
committee. 9/3/2015. And that, my lord, by itself is
9/3/2015.
15, my lord. He is already there, my lord. For promotional purposes, because there is no exit here. Promotional purposes, that has been kept. That by itself, my lord, will not take him, because I'm not saying, my lord, anything else, otherwise saying that he is a member of 2C, my lord. Because protocol officer is not under challenge. What is under challenge is the secretary to the HCJ. So, my lord, if he is a member of 2C, then, my lord, that consideration will automatically.
But they're trying to project that he is not a PO, but he's a SJ.
That's because of that line, which I say, my lord, is a misnomer. Which, my lord, is admittedly a misnomer. Otherwise, my lord, how do he get a gazetted status there? He's enjoying a gazetted status there. He's enjoying the perks of that post, which is admittedly higher than that of JA. It's equivalent to, my lord, administrative officer. Promotion. And the appreciation, my lord, the submission of the petitioners, whether this is a promotion, and the, my lord, subject to what my lord would say, the appreciation of the Honorable Single Judge was also on the premises that this is a promotion, which admittedly it is not. My lord, the records, I'll just make an index and I'll post it.
Wait.
Today, it's no.
Wait a minute. Let me hear.
Wait for a minute. Wait here.
Probably we will not finish it today.
Yes.
But can you give me a small gist of your?
Yes.
Mr. Mahanta will just let us get an idea of what.
My lord, my learned friend is privy to the records. Now, why that line is there? That he will maintain seniority as senior judicial assistant. That's very significant.
Yes.
Why we have not challenged the order of either promotion or appointment as protocol officer? That perspective I would like to keep my. And which is so relevant in this case. Now, what had happened, my lord? When the records are produced at page 28.
Just a minute.
Can you take note?
Your basic case is that why you have not challenged the promotion?
Because my lord, there is a rider in the order of the appointment as a protocol officer, saying that he will maintain his seniority at the grade of SJA, Senior Judicial Assistant. Now, my lord, can we conceive in a service jurisprudence of a situation, a man is promoted as executive engineer, appointed as executive engineer, he will maintain his seniority as assistant executive engineer. It can't be. And if such an order is passed, there has to be a reason. I would like to answer that reason. Now, what had happened, my lord? This post of protocol officer was created in 1999. Ever since his appointment till date, my lord, the rule is not there. How it will be filled up, etc., etc. From time to time, my lord, committee of the judges sit and take a decision. That is how it is being appointed. Now, my lord, on 11/12/2013, a notification was issued by the Chief Justice on the administrative side, my lord. Kindly take note of that.
11, 12.
12/13
Yeah.
by the Honorable CJ, my lord, which is available at page 28 of the 28C of the records. Wherefrom Lordship will
Page
notice.
28C.
Yes, madam. Wherefrom Lordship will find zone of consideration for all posts under the High Court has been determined to be 5. If there is, my lord, 1 post, 5 persons case has to be considered. Then next, my lord, I will request your lordships to take note of page 54C.
Zone of consideration for promotion.
All staff, my lord. Promotion for filling up any post,
Acha.
filling up any vacancy in the High Court.
For appointment to any post.
Yes, the zone of consideration is 5. 1:5. Then, my lord, next I will have your lordship's kind attention to page 54C. From records, the lordship will find. My lord, this is the minutes of meeting dated, minutes of the meeting of the Committee of Honorable Judges dated 9/3/15.
Dated?
9/3/15.
Yes.
Wherein it was, my lord, decided that PO or assistant protocol officer, they will maintain their seniority at the grade of senior judicial assistant.
Thereby implying?
I'm coming. Now, what had happened, my lord? Now, this practice was normally what they do, they invite options from some of the employees and they, my lord, appoint. Then, my lord, Employees Association submitted a representation. They say, how come this practice? There is no rule, no nothing. There could be arbitrariness also. So therefore, they submitted a representation. Now, this criteria of inviting application was objected by the association. And another thing, my lord, which was decided was, then, my lord, this representation was placed before a committee of 3 honorable judges. They comprised of Honorable Justice Rishikesh Roy, Honorable Justice Ujjal Bhuya, and Honorable Justice Suman Shah. Then, my lord, that committee went through the procedure which is followed in different high courts. Amongst others, my lord, the committee took note of the practice being followed in Kerala High Court, where, my lord, the practice is for such type of appointment, it is at the pleasure of the Chief Justice, sort of a displeasure, not pleasure exactly. During his pleasure, during his tenure, he can appoint somebody. The moment, my lord, that Chief Justice goes, the subsequent Chief Justice may not like to retain that protocol officer or private secretary. Therefore, he will go back to his original position. That is why, my lord, his seniority is being maintained there.
But where do we get that from?
Yes, my lord, record. I'm talking from record. What I'm saying is everything is available from record. This is, my lord, page 31 of the record. that Kerala model was adopted, that your lordships will get in page 31 of the record. My learned friend should have pointed out this fact. He's making argument that no, he has not challenged the order. But why is he not saying what record reveals? This writer, this is the reason.
Whether it was a discussion or decision.
There will be 100 things here for the decision making process. But that's not the relevant.
Anyway, let us hear the other side. That is this his submission.
My lord, therefore, this is the reason why we find that clause in the order. My lord, even he was appointed as private secretary to the Honorable Chief Justice, that clause was there. Kindly see, my lord. Kindly
No,
see.
no, it's okay. We'll
Ah.
see that. We'll see that. We'll just hear you now because
So now this is the reason why we have not challenged the, my lord, the reason is very simple. Even this private secretary, until he was regularized, suppose he has been appointed as a as a secretary to the Honorable Chief Justice by invoking power under 7(3)(a). Now the successor Chief Justice may not like him. He may like to have another Chief Justice, private secretary. Then what happens? He will be made deputy registrar. My lord, we have to interpret the rule giving some meaningful meaning, my lord. We just can't, my lord, go on beating around the bush. Supposing the incumbent Chief Justice feels that I will not have keep this man as a Chief Secretary, private secretary, then what happens? He has to maintain his seniority in some grade. That is why, my lord. So, my lord, basically these are orders passed at the pleasure of the Chief Justice. Therefore, at the end of the day, my lord, a Chief Justice has a right to choose his own private secretary, as long as he is holding the office of the Chief Justice.
just a minute.
My lord, I'll place judgments of the
No, no,
Supreme Court.
just let me see this
Yes, Sankita.
schedule one.
My lord will kindly come to page 640 or schedule, my lord.
664. Okay, so secretary to Chief Justice is assistant registrar.
Yes.
Two AA, 2A, which includes the cadres of assistant registrar and secretary to Honorable Chief Justice.
So therefore, my lord, there is a reason. None other than High Court, my lord, on the administrative side is passing an order that a person has been appointed or promoted as a protocol officer, but he will maintain his seniority at this original grade. Why? Some meaning has to be given. Either the meaning which I am trying to give or the meaning who is trying to give. They are trying to give. But some meaning has to be given. এখন 2200 কথা কব লাগিব না অনুচ্ছেদ
This
and my lord
this second
my lord will
procedure-
kindly take note of one more page, my lord. Page 122 of the note sheet. Page 122 of the note sheet, that is minutes of meeting of the committee held on 23/11/16. But whereby, my lord, the respondent appellant was appointed as
minutes of
minutes of meeting of the Honorable Judges Committee, my lord. Honorable
Dated-
Justice H. Roy, UP and S. Shyam.
dated
Dated 23/11/16. Item number 2. My lord,
so no, just a minute before that, this secretary to the post of CJ
yes,
and assistant registrar, they are interchangeable posts. I mean, they can be transferred.
Equivalent.
yes.
Equivalent.
Huh?
Equivalent.
Equivalent, that is all right. That much I know. But they can be posted
Yes, yes.
either way.
Now, my lord, in fact, now he is sought to be promoted as deputy registrar. That is when, my lord, we came. There is an interim order, no? There was an interim order by the single judge, not to give effect to that process. And my lord, now, of course, the petition has been allowed. Now, of course, there is a stay order operating in this regime. That is continuing. Though there is a stay on the judgment, but there is no stay, no stay on the further promotion to the post of.
There's another writ petition, writ appeal.
No, my lord. During the pendency of the two writ petitions before the learned single judge, a move was made by the High Court to promote him as a deputy registrar. In fact, he was sought to be considered. Then we moved an IA, my lord, where an interim order was passed. Eventually, my lord, everything merged with the final judgment of the learned single judge. When the appellant and the High Court preferred this present reset of writ appeal, though the judgment has been stayed, but that part of the order has not been interfered at the interim, by way of the interim order. So that order preventing the High Court from further considering his case for promotion to the post of deputy registrar is holding the fit. So page 122 note sheet, the minutes of the meeting of the Honorable Judges Committee and my lord, the proceedings preceding that will clarify what I am submitting. Why Kerala model was adopted, why that zone of consideration was brought in, and all these things are there. Why we filed the representation, and based on the representation, what decision was taken. So these are all relevant, my lord. So my learned friend may laugh away, but I think what I am saying is there is some substance to be considered. Then I will make my submission following what they complete, my lord. I'll give my reply. So therefore, my submission, this is the reason why we did not challenge the order of appointment of the appellant as a protocol officer. Because we never felt.
But since you have not challenged it, then it remains unchallenged, whatever may the reason. We do not know.
Yes.
Because
No,
you see,
yes,
that is
technically,
subjective.
No, technically lordship is correct, absolutely correct. Yes. Now, question is, my lord, what happens if when as the question which I am posing for lordship's kind consideration, if the incumbent, the successor chief justice says, no, I don't like this man, then what happens? That is the reason, my lord. The Kerala model is that, which was adopted by this honorable court on the administrative side, by the judges committee. Prior to that, that is why the representation was filed, and representation was taken to its logical end, whereby this decision was taken.
All representation.
And my lord, regarding invocation of power under Rule 63A, there are decisions of our High Court, my lord. There are decisions of the Supreme Court. My lord, one thing lordship may kindly have a look. If a lordship should kindly come to the Constitution for a moment, my lord.
But before that, whether the appointment of the appellant to the post of PO, is it a promotion? Or is it I don't know, is it a direct recruitment or what is it?
Sort of a, my lord, it's a sort of a direct recruit. Promotion, actually, it's a career progression, yes. But the manner in which it has been done, it looks like, my lord, it's a selection.
Very fair.
Very
Very fair. It's slightly confusing. Because calling for an option.
Though High Court decides others matters, my lord. But house is, problem is there in his own house.
It happens. It usually happens.
It normally happens.
Normally, not normally, but it happens.
My lord, my learned friend has said I am fair. That is why I am K.N. Chaudhary, my lord. Just to please somebody, I will not make any submission in my life. I never did. I will not go against my conscience.
And I am a person who will say what is true. But
Anyway, the thing is that, you see, because one of the issue is whether it's a promotion, can it be said to be a promotion?
No, my lord, my perspective would be slightly different. Be it promotion or be it an appointment. Question is, my lord, the manner in which it has been done. My lord, some status has to be given to that either appointment or promotion. That's the issue, my lord. When we are not trying to find fault with that in that sense. What I'm trying to say is, my lord, what is the status lordship would like to give to that appointment? Whether it is coterminous with the tenure of that chief justice, or it will continue,
Anyway,
or it will continue to get further career progression based on that appointment.
anyway,
That's the point which calls for.
the selection has not been challenged.
My lord.
The procedure and the selection has not been challenged. That is clear.
Yes. But my lord, but that's why
Only
I
thing
say,
is, we'll have to see whether it was the Kerala model that has been followed or not.
yes,
That is, okay.
that is the, my lord, that is the professed norm which High Court adopted. If that be so, where is the question of giving him further promotion from thereafter? And prior to that, my lord, this was not there in the High Court records. If your lordship goes to the record between 99 and 2016, lordships will not find any such decision. It is only in the eve of this November 2016 decision that it was taken.
So if we are to hold that the Kerala model has been followed,
Yes,
then it's in your favor. If we are to hold it's not, then it'll go that side.
maybe. Well, look, that
I
will be
mean,
your
in a-
lordship.
I mean, in a very simple term.
Yes. And the records will reveal, my lord, actually, my lord, I asked my colleague, please go through the record, let us see why this was added. We are also very curious to know. That is what is revealed. This what is discernible is that.
Let me finish.
I don't think you've got time.
I'll
You see,
My lord, we'll fix a date.
The reason being, now time is there, and plus I've got another meeting and I've got some pre-meeting meeting.
And my lord, this is the record of the Honorable Secretary to the Honorable Chief Justice.
Yes,
There is nothing called a Kerala model here.
anyway, we'll see, because he's giving me dates. And we'll have to see.
There is nothing of that. So they are confusing the records. Mark. That Kerala model was there in the protocol officer thing that
We
something
are
was
talking
brought
of
into
protocol
them.
officer only.
Yes, we're talking about the protocol.
They say, Manat CJ. That's why. When he submitted, he said CJ.
You know, it's on the protocol model.
That was never adopted. 9/3/2015 is the final.
My lord, we are talking of.
No, he's saying that the 9/3/15 meeting, okay, 9/3/15 meeting is based on the Kerala model.
No, that I never said.
That
What I said is, my lord-
23/11/16.
yes, no, my lord, I'll give the sequence. My lord, when the representation was
14.
filed by the employees committee, my association, they objected to that procedure of making appointment by calling for objections. Sorry, by calling for, my lord, the applications. Then, my lord, the matter was given before a particular judges committee. Then judges committee went through the models which is being adopted by other high courts. I think 3-4 high courts model were taken note of. They found this Kerala model to be ideal. So they adopted the Kerala model.
When 9/3/16, this
Prior to that, my lord. Lordship, wherever lords-
23/11/16. Page 122 of the note sheet.
One second.
122 is by the recommendation of Judicial. 122 says the recommendation of Judicial.
When was the notice issued for option?
Option notices were, my lord, on 141, my lord. It was on 2/9/2016.
2/9/16
Lordship.
option.
My lord,
Yes.
what had happened, my lord, based on the representation, it was sent before the registrar. Then I think registrar placed it before the Honorable Chief Justice. Then Chief Justice, my lord, made all these queries. Where from, my lord, they found this Kerala model. In so many words, it is not there that they have adopted, but having gone through, my lord, they have noticed that and taken note of that.
And what is the date?
My lord says, voting of Kerala model is at page 31 of the.
Date. You're not.
Page 31 of the
Just
record.
look at page 31, let us see the date.
Note sheet, huh?
Note sheet, no.
Note sheet.
Page 30, note sheet, no.
Itu kota. I could have.
দেখা যায়? আছে?
This is there, my lord, but.
Which
this
page,
was-
which,
uh,
which?
page-
So it-
page
so
13,
the
this
page
is
could
a
not
note
be
of-
more.
Note dated, my lord, it's of
Page-
2/6/2014.
Page 31.
31. Note
That I, but which date was it?
2/6/2014, that notice of 2/6/2014.
No, notice I'm not on that.
No,
That
no,
Page 31. What
That is,
date?
the date is 2/6/2014. Note sheet.
That is prior to the options.
Lordship.
Yes.
And that, my lord, finally, it went to, I'll just verify that, my lord. It went to the committee on 25/7/2014, 28N.
Anyway, we'll see on the next day.
Lordship. And therein, without anything said, ask for options. Then, my lord, next stage is 9/3/2015, where this was at.
My lord, the idea is the Honorable Chief Justice has to be given that discretion to select a person who would be his lordship's private secretary or protocol officer. The idea is, my lord, it will be a court organized. Further, if you are to get some benefit based on that, if that was the intention, then he would not have retained his seniority as same. That is my humble submission. If that is the idea, my lord, then he should have, ceased to be as a. Then he could have challenged that. How come I'm maintaining my seniority at my lord senior as a, though I'm at 2C? He never challenged that. Yeah, he is appellant, very much appellant before this honorable court.
Okay, we'll list it
Well,
another day.
Well, before vacation, after vacation.
Whenever you want, I do not know.
Let it be after vacation.
Okay. After vacation. After vacation.
Let it be
And
hard.
go
argument.
through it again, my lord, it will, also, my lord will have it. Next week, my lord. Monday or Tuesday, finish it up, only that small issue is left now.
What small issue? I giving me such a big, for you, small issue. I have,
We will complete it within a short time.
Substantially, my lord,
Because
it's got the.
substantially hard. Substantially hard.
Let it be after vacation, man.
We have some. other-
okay, we'll fix next week if possible.
Okay.
We'll hear, then we'll continue maybe to that.
Yes.
I just want to see.
Let us make an
proper-
attempt before vacation. If that is possible.
No, yes, that
22nd,
is- we'll attempt to dispose.
So that lawsuits will be able to write the judgment during vacation.
No, no,
While you all go off to London, like all the, half the North Indian lawyers now are in London.
Yes. For our birth function,
Yeah.
we are thinking of bringing some, my lord, retired judges.
Ah.
Nobody is present in Delhi, my lord. All are in London.
Yes, all are in London, I know.
Because for the yesterday's function, my lord,
Uh-huh.
we tried 2-3 options, my lord.
Ah.
The answer came, nobody is in Delhi.
Yes, yes. Even my friends and my lawyer friends in Delhi, they're all gone. They're all gone. Someone is in Scotland, someone is.
It will be always better to finish it before vacation so the lawsuits will be free to move around.
No, then you'll have us writing judgments while being in the Western hemisphere. Anyway, yes, we can try. Only thing is that, when, 22nd, 22nd, okay. Let's,
No. My lord,
Okay.
22nd, it is simply not possible
yes.
that, my lord, Sikkim matter is fixed.
Yeah.
As some matter has been referred by the
Uh-huh.
Supreme Court. Lordship, Lordship can have it on 26th, my lord.
26.
26 or 27, madam.
That is just before vacation,
Ah.
very difficult. It was, tell me,
My lord,
very,
have
very
it in
difficult.
Next week, my lord, on Tuesday, not possible, then Thursday.
Tuesday we have fixed matters.
Then
No,
Thursday.
no, Thursday not possible.
Thursday.
Thursday, my lord, 2 heavy matters are there
Yes, yes.
before court.
No, we'll accommodate everyone.
Yes.
Let it
We
be
can try on 26th, my lord, it's a Monday. In the second half only, my lord.
I'm having this we're having this criminal bench and though we sit here, all the thinking starts being done after sitting here. Because we've got lots of records to go through.
It happens well. It will keep on repeating.
And then we can do that.
We can try on 27, but may not be completed. Let's see, because I'll have to see all the records and all.
Yes.
Place it in a fashion.
Don't just place it.
No, I'll index it.
We can try. 27.
It's better lordship goes to the record, my lord.
to
He
go
might,
through.
he might flag those pages in his favor.
That is what I'll have to go through
Yes.
everything. And maybe ask queries on the basis of
Can
that.
it be on
Yes.
21 if not inconvenient?
Huh?
Can it be on 21 if not inconvenient?
21 at 2 p.m. madam.
At 2 p.m.
Let's give it a 5 minutes.
I don't know.
21st, madam, my friend,
21st,
senior have problems on 21st,
Let it be 26.
21st, madam, so that it can be if required.
There has to be a common meeting ground.
Yes.
Let there be a common meeting ground.
Or I can agree to one thing, my lord, let on 21st, they complete their side, I give
Yes,
my
yes.
reply on 26th.
Okay. Fine, fine.
That
21st. Okay. On the prayer, heard Mr. K.K. Mantal, Senior Counsel, Mr. U.K. Nair, the Senior Counsel, and Mr. K. Chaudhary, the Senior Counsel. This is the matter. On as paid for by them, this is the matter on 21. At 2 p.m.
Yes. They will complete their part, man, I'll do my on 26th.
I couldn't even dictate, which I usually do a little bit.
Madam, normally does. 21st, my God, madam.